Good afternoon, everyone. Welcome to the Appellate Division First Department. We have oral arguments for today, February 20th. So again, as you probably all know, please ask for the time that you need in order to get out the salient points of your argument. We are fully familiar with your briefs and with your argument. The red light is for you, not for us. If the panel has additional questions, we will certainly put those questions to you regardless of the light. People v. Shamir, Doctor. 524. Lona Rubio versus COA 200 East 34th Street. So we have 6, 3, and 3. And who did I miss? Oh, the first respondent, how much time did you request? 5. 6, 5, 3, 3. Matter of L. Michael, that matter is submitted. U.S. Bank N.A. versus Galant. It's afternoon, but that's okay. Do you have a cross appeal? Do you have a cross appeal? Did you want any time in rebuttal, or you just want the straight 5?
No, there's no cross appeal. It's just
Okay, so 5 minutes. How much time are you requesting?
Respond to the cross 5 minutes as well.
5 and 5. Harbinger Capital versus Apollo Global.
for appellant, Your Honor, 12 minutes, 9 minutes, and 3.
Good afternoon, Your Honor. For the Apollo defendant respondents, 6 minutes.
And for the appellees, CCTV and Singh, 4 minutes.
Okay, so we have 6 and 2. Apollo has 6. TV, how much were you requesting?
I requested 4, Your Honor.
4 minutes. Cedar Capital versus Lilly.
Our respondent, 4 minutes.
6 and 2 and 4. People v. Andre Fernandez.
Good afternoon, Your Honor. Appellant request 7 and 2. Good afternoon, respondent request 7.
626. Lucas versus the City of New York.
Good afternoon, Your Honor. Respondent Lucas, 4 minutes.
Respondent Workwell, 3 minutes.
So we have 6 and 2, 4, 3, and 3. JD Construction versus Cooper Services.
For appellant, 5 and 2, please. And for the respondent, Your Honor, request 5.
525. Matter of Corral B versus Tiffany B. That matter is submitted. Harnish versus the City of New York.
Michael Joseph, for appellant, Your Honor, 5 and 2 would be fine.
Good afternoon, Your Honor. According to the
525. People v. Pedro Hernandez.
Appellant, 7 and 3, Your Honor. Respondent, 7, Your Honor.
626. Halley versus Craven.
Good afternoon, Your Honor. For appellant, 6 and 3.
525. People v. Jose Laura. Matter submitted. Tam Consulting versus Cincinnati Insurance.
Good afternoon, Your Honor.
You, Tam? And how much time are you requesting? Who else do we have? Cincinnati? That's 5, 4, and 3. DKC Group versus Reese, that matter is submitted. First case for argument is People v. Shamir Doctor. Yes, whenever you're ready.
Good
afternoon, and may it please the court. My name is Catherine Keene. I'm pro bono counsel from Kramer, Levin, Niftalis, and Frankel, along with the Legal Aid Society for Mr. Doctor. Our request today is for a modest reduction of Mr. Doctor's sentence of 3 to 6 years to 2 to 4 years. Mr. Doctor's sentence is excessive for a number of
Can
reasons.
we address the waiver?
Yes, Your Honor. The waiver should not govern due to a variety of defects in its administration. First, because the court below didn't distinguish between Mr. Doctor's trial rights, which were automatically forfeited, and his appeal rights. Additionally, the trial court below didn't explain to Mr. Doctor that he retained his rights, that he could file a notice of appeal, but waived his right to an appeal. And because Judge Ross did not distinguish what rights he retained, he did not understand what rights he was waiving. Thus, it was not knowing, voluntary, and intelligent. Additionally, the written waiver doesn't cure the defects in this oral colloquy for a variety of reasons. In People v. Ramos, the Court of Appeals explains that a written waiver only cures a defective oral colloquy where defense counsel fully advises the defendant on the written waiver, and that did not occur here. Additionally, the written waiver was invalid because Mr. Doctor was asked to sign that waiver prior to the description of any of its contents.
Well, I believe he was unable to sign on his own behalf because of the shackle. I think he had the mitts on, so he couldn't sign on his own behalf. But his attorney signed on his behalf, and I believe that it was stated in the record that he had authorized his attorney to do so.
Correct, but in People v. Echeverria, the court explains that the court didn't confirm that Mr. Doctor understood the contents of the waiver prior to his signing it. And New York courts have
The judge did not inquire as to whether or not he had read the waiver?
No, Your Honor, not prior to his signing it.
I'm sorry, you're stating that the judge did not inquire as to whether or not he had read the waiver prior to he, the defendant, authorizing his attorney to sign on his behalf?
Correct. The Judge Ross asked for everything to be signed prior to both asking if he signed it and asking if he understood the contents of the waiver.
And you're stating that, how does that detract from the defendant's ability to issue a knowing and voluntary waiver?
In New York, the written waiver is not knowing because he didn't understand the contents prior to signing the waiver. He couldn't go back and then say he didn't understand the contents of the waiver after he had signed it.
I'm sorry, go ahead.
Counsel, can the court forego the appeal waiver colloquy in its entirety and merely rely on a written waiver? And if not, if so, why? And if not, why not?
I'm sorry, could you restate the question?
So, generally speaking, the court gives an appeal colloquy, and then there's a written waiver that accompanies the colloquy, right? My question is, can an appeal colloquy given by the court explaining the rights be substituted for by a written waiver?
There might be some instances where a written waiver could substitute the oral colloquy. However, in this case, the written waiver cannot substitute the oral colloquy because Mr. Doctors didn't have the opportunity to have that written waiver explained to him by his defense counsel, which is required by New York courts.
We don't know that. The attorney signed on his behalf. We don't know whether the attorney read it over with him or not. But counsel, in terms of the sentence reduction, he was sentenced to 3 to 6. He was a pred for a 2019 weapons possession case. In this particular case, it was a robbery. Although he pled guilty to the rob 3, it was a gunpoint robbery. At least he motioned or indicated to 2 individuals who were dragged out of an elevator that he had a weapon, and he proceeded to forcibly take property from them. So why then should we reduce it from 3 to 6 to 2 to 4?
Your Honor, just a point of clarification. There's nothing on our record that indicates that it was my defendant that had the gun on him.
But he was acting in concert with someone else, is that correct?
Yes, Your Honor. But in this case, my client, if I could just answer your
Please.
question, my client has shown remorse in this case, which is in New York courts is a factor that this court has used in reducing sentences. Additionally, this court has found that age is another factor that might reduce culpability. My client was only 19 at the time of this crime. And this is another factor that
I thought he was 23.
No, Your Honor, he's 23 at this time.
Oh, I see.
He was 21 at the time of sentencing, and he was only 19 at the time of this incident. And this is another factor that may render a defendant less culpable.
Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Stacey Nadell for the people.
So, counsel, if you could please address the issue as to the waiver, both the allocution as to the colloquy conducted by the judge, as well as the written waiver.
Yes, Your Honor. The waiver of appeal in its entirety forecloses a review of defendant's sentence at the outset. There was an oral colloquy, which was supplemented by a detailed written waiver.
And what was exactly said during that oral colloquy? Was there anything regarding the fact that the waiver of right to appeal was separate and distinct from waiving the trial rights?
Yes, Your Honor. First, the court discussed the rights that were automatically forfeited by the defendant by pleading guilty. The trial rights of the right to remain silent, the right to a trial, the right to call and confront witnesses, and the right to contest any search and seizure. The court then turned to the appellate portion of the waiver by saying, Mr. Doctor, when a defendant pleads guilty, he usually retains his right to appeal to a higher
Counsel,
court.
But stop there, because I have it written down here too. Where was the distinction made between the waiver of the trial rights and the waiver of the appeal rights?
The discussions were separate. There was the automatic.
No, where in the transcript is it?
Uh,
'Cause I didn't see it.
I don't have the page number.
So, for example, counsel, did the court say specifically that the waiver of right to appeal is separate and distinct from the other rights that the defendant was giving up?
The court did not use those words specifically. However, there was a separate conversation about the right to appeal to a higher court. And while the court did not explicitly detail the appellate rights the defendant was giving up, as well as the court could have explained, by having the detailed written waiver to supplement the oral colloquy, that is enough for
Well, let's stay with the oral colloquy for a moment. The court stated that because the defendant had been offered a beneficial plea conditioned on him giving up his right to appeal, he would be giving up his right to appeal the conviction to a higher court. Is that correct?
that.
I mean, that's the statement that was made. Is that statement correct?
That statement is
That was kind of a rhetorical question because it's clear that that statement is incorrect.
Because even though he waives his right to appeal, there's some rights that he would still retain, right?
correct, yes. And the court did not explicitly detail those rights. That the court should have for.
Is that a problem, counsel? And I go to the question that I asked your adversary, which is in the absence of an appeal waiver, an appeal colloquy, a sufficient appeal colloquy, is a written waiver enough?
The written waiver on it, the oral colloquy is the waiver. It's best to supplement with the written waiver. Having the written waiver on its own would not be enough. There needs to be an oral colloquy by the court. But because we have both here to complete the entirety of the.
Well, let's turn to the written waiver. You, in your brief, you state that in response to the court's questions, defendant confirmed that he had read, understood, and agreed to the conditions set forth in the document, and that he authorized him, meaning the attorney, to sign a document on his behalf. Where in the record is there any colloquy or questions by the court as to whether or not the defendant, had read, understood the conditions, and authorized his attorney to sign on his behalf?
I don't have the exact page number. It would be in our.
I didn't see that there was that discussion.
The court did ask the question if the defendant understood the terms of the written waiver, I believe. And the record does reflect that the defendant did discuss with his counsel the terms of the waiver. He was satisfied with his attorney's representation, and the court said, if you're confused at any time, please bring that to our attention. And the court, at various points in the colloquy, said, do you understand? Is that correct? Are you confirming your understanding?
And your position as to the sentence reduction from the 3 to 6 to the 2 to 4?
Your Honor, the sentence was fair and appropriate given the facts of the crime. The facts of the crime were very serious. The victim suffered injuries. This wasn't an incredibly lenient deal. The defendant could have been charged with first and second degree robbery, facing a maximum of 25 years incarceration, but instead walked away with a nonviolent felony of robbery in the 3rd degree. And in light of his criminal history and the fact that the sentencing court was fully apprised of the mitigating factors that the defense raises today, the sentencing court was fully aware of that, and there are no circumstances that would warrant any sort of reduction.
Thank you.
Thank you.
Your Honor, to answer your
In terms of
question.
the appeal waiver, this wasn't defendant's first plea, right?
Your Honor, I'm actually unaware if he had a
Didn't he plead guilty in June 9th and June 11th, 2019 of attempted criminal possession of a weapon in the 2nd degree?
Thank you. That's what he was a predicate for the possession, the weapons charge.
Yes, Your Honor.
Right, so that meant he had previously entered a plea of guilty.
Yes, Your Honor.
I mean, he had other pleas too, but those were as a YO. But this was as in June 2019 was. Where does the fact that he's got a prior plea, isn't that a factor in the analysis of the validity of the waiver?
I'm sorry, if the validity of the waiver?
Yeah.
Your Honor, his prior interactions with the criminal legal system all occurred when he was a teenager. He was only 19 years old at the time of this crime. The 2019 crime, he would have been 18 years of age.
Right.
And all of this goes towards, and age is a factor in determining knowledge, knowing, intelligent, and voluntariness of a waiver. His understanding of the waiver at the time when he was 18 years old should also be considered at the time of this crime. Mr. Doctor only has a high school diploma. He also has ADHD. So his understanding of the waiver should be determined on its own terms for this particular crime. It's also between 2019.
Well, it's not a matter of whether it's for this particular crime or the prior crime. The point of that prior plea is his familiarity with appeal waiver concepts.
Do we even know if there was an appeal on that prior matter? A waiver of appeal? Waiver of his right to appeal?
To answer your question, Your Honor, no, I'm not aware.
Thank you. Thank you both. And also, you're doing this pro bono?
Yes.
Yes, thank you very much. Thank you, and thank your firm as well.
Thank you.
Lona Rubio versus COA 200 East 34th Street. Would someone like to argue first, like the appellant? Thank you.
Afternoon, Your Honors. My name is William Pager on behalf of the plaintiff appellant. Your Honors, we ask that the court review the record and reverse the order of the lower court. I believe it's...
So your client was employed by non-party court, is that correct?
Correct, Your Honor.
Okay, and so the motion court granted the motions of Moncon, Real Plumbing, and Murillo Plumbing.
Correct, Your Honor.
So let's start with Moncon. What was the nexus or relationship between your client and Moncon in terms of their either supervising him, supervising the work that he did, or anything of that nature?
This is the complication in this case, Your Honor. Your Honor, my client is a very young man who had very recently
Don't tell
joined.
me he's 17 or 18 years of age as well.
Pardon?
Don't tell me he's 17 or 18 years of age as well.
He's not very far off from that. I
Okay.
won't.
So how does that play into whether or not he was aware as to who directed him to perform certain work or supervised him? How does that play into it?
Very good question. The reality is that he had just recently become a construction worker in the capacity of a helper. He gets a job in on this particular construction site. That's
We
his
don't
first.
look at this, we're talking about statutory liability. I mean, it's not the plaintiff's circumstances which determines whether the defendant is statutorily liable. What is it about Mancon that should bring them under this statutory liability?
Complicated fact pattern, Your Honor.
No, it's not complicated at all. Mancon puts in an affidavit by someone with knowledge who says, we didn't supervise the plaintiff. We had nothing. We didn't hire him. We didn't pay him. We had nothing to do with his trade. Now, the plaintiff should know or have some information himself about who supervised him, who paid him. So unless he can put up some kind of one factual issue, then those affidavits and everything else that goes along with them carry the day. So what did your client put in except for, I don't know who supervised me, I have no idea, I didn't get enough discovery yet? Assuming that that was the only thing, is that all your client said? Although he has been working and he gets paid and he knows who talks to him every day.
Right.
So other than that, did he put in anything?
So the fact is, we're complaining about the fact that Mr. Lona Rubio is provided with a hard hat, which is discreetly inappropriate for the
But
task.
was Mancon the one who provided
We
that?
don't really know at this point.
They weren't supervising his work, and they were working on the 21st floor on the day of the
We
accident.
Right, they weren't even on the second floor.
Number one, we don't know what, first of all, we don't know where second floor
I
comes
mean,
from.
Mancon is the concrete superstructure contractor, and this happened on a hoist, right?
Correct.
And we have an affidavit
exterior
from an
hoist.
employee, we have an affidavit from an employee of Mancon who states that Mancon was not present on the second floor. So again, as my colleagues have asked you, what did your client submit in terms of any supervision or anything by Mancon, or even stating that Mancon was on the 22nd floor?
Okay, what I would point to, Your Honors, is what we're primarily arguing here is someone gave my client the wrong hard hat, and we don't know
Who gave
that
your
is.
client that? Your client's the only one who knows who gave him the hard hat.
He might know facially the person, but he would not know who's responsible for site safety.
So did he identify who gave him the hard
No
hat?
discovery, Your Honor. That's
No,
the
you
problem.
don't need anybody else's discovery. Did you ask your client who gave you the hard hat?
He's going to be able to say a tall, dark gentleman with
So what discovery, you want a lineup? Because, you know, we're drawing references to a criminal case. Do you want a lineup for everybody who was on the site? He's going to do some type of identification procedure? I'm not sure. What would the additional discovery, or what would discovery lead you to?
The additional discovery would lead me to understand who's in charge of making sure that people have the right site safety equipment, hard hats, and who was.
So we're back to the fact that Mancon, Rio Plumbing, and Marine Plumbing all state that they did not have anything to do with the supervision or, of your client or any interactions with your client.
Actually, they don't actually say that. They offer affidavits, which I pointed out are are drawn in a very conclusory manner, and they don't actually address the issues.
Counsel, so we don't have any information, for example, as to who was the site safety manager?
Nothing,
Or
Your
what the problem is the lack of a nexus, at least as far as the record seems to tell us. So we have one defendant involved with the concrete superstructure, the one we're speaking of now, real fire protection, marine plumbing. We're talking about a very serious accident, right, that took place on an exterior hoist elevator,
Correct.
all right? There doesn't seem to be a relationship between the the responsibilities of these individual companies and, or defendants, and the elevator. That
Your
even
Honor,
that they would be using it.
The only thing I can say, Your Honor, is that it's very premature to say that, because at this point, with a completely undeveloped record, we have no idea who's responsible for what.
They all submitted affidavits stating that none of them employed, supervised, or had any obligation to exercise authority over your client, his employer, which I think was CORE, or the hoist. So
Or the-
again, or the hoist, the elevator that the accident allegedly occurred in. So
Nothing about
again,
equipment, Your Honor.
I'm sorry?
Nothing about equipment.
Did you ask CORE I mean, this is the point. You have access to all the information. CORE knows who gave him the hat if he doesn't know himself. CORE knows who's involved, all of that. So I'm not really clear what you think you need that you need discovery for.
What I need, Your Honor, is depositions. I cannot ask, unfortunately, in my life, it doesn't work as simply as going to somebody and say, do you remember who was responsible on this particular construction site for this particular aspect, and have them commit? That would be something that I could present on a record in a deposition. I wouldn't be
You
entitled to it.
named these defendants, you must have had some basis for thinking they were involved.
These are the contractors who are working, according to my client, according to the DOB records, and
So you just named anyone that was present at the scene?
that's kind of my job,
Any
Your
kind
Honor.
of work?
No, well, I don't know if that's kind of your job, but your client was able to name these individuals, but he was not able to come up with any other information. He could name the three contractors, or these three contractors who were on the premises at the site, but he couldn't tell you who gave him the hard hat,
I
or
think
give you any other information concerning their possible liability.
I think if you, I don't want to misstate the record, but if you look, he was on the job for something like a week or a very short period of time.
Thank
And-
you. You do have time on rebuttal.
Oh, if that's the case, I'll, but, and.
Oh, I'm sorry, you don't have any time on rebuttal.
Okay, Your Honor, just one last thing, if you don't mind. The Supreme Court in Brooklyn had looked at the same identical record and decided that the record should be explored a little further, denied summary judgment on the same exact record.
No, that's not
No,
right.
well.
That's not right. The bill of particulars hadn't been served. There are plenty of things that happened after that first decision.
Bill of Particulars does not,
No, but in terms of distinguishing that case from the facts here, that
the only
case is-
difference is the Bill of Particulars. That doesn't shed light one way or another.
Thank you.
Thank you.
May it please the court, Costa Cypress from the law firm of Welby Brady Greenblatt on behalf of Respondent Marine Plumbing and Mechanical, Inc. Right at the outset, I must say that there are certain incorrect assertions that was made by appellant in oral argument, including that he was newly on the job, and that's on the record. That is definitively not on the record in any which way. That was just included as a point of argument in the appeal papers, one. Two, Core Scaffolding is actually a party in this action. They were initially brought as a third-party defendant and are actually a defendant. Taking those errors aside, the lower court was correct to grant summary judgment, and it should not be reversed.
So, counsel, your client,
Marine Plumbing.
they were in charge of gas welding and piping.
Gas welding and pipe work, and they were performing that work on the 21st and 11th floor based on the project records available and submitted on the record on that day, Your Honor.
Interior of the building or the exterior?
Interior.
Of the building? The interior.
Correct, Your Honor. And based on the record at hand, we provided another aspect that was addressed by the appellant counsel was that the affidavits and proof does not address the unavailability or lack thereof to provide hard hat and equipment. And I refer to you to the record on the record 1105 of the record, where my Marine Plumbing's director of safety at that time specifically said we did not provide safety equipment to people who were not employed by Marine Plumbing.
And did the plaintiff raise any issue with respect to that? Did the plaintiff
they did
put in
not,
an
Your Honor. They-
affidavit
and-
that
and in
said,
fact-
no, yeah, I got that hard hat from someone from
There-
Marine?
In fact, Your Honor, if you actually look at the record, there actually is just an attorney affirmation. There is, in fact, no affidavit from the client. It was just an attorney affirmation here, which is another incorrect
Did
statement.
the plaintiff, right, so below, the plaintiff did not put in an affidavit who said, I don't know who gave me the hard hat.
Correct, Your Honor. If anything, they actually admit in the statement of material facts that he was performing work for his employer, Core Scaffolding, at the time of the incident on the exterior hoist. So this is an exterior hoist maintenance operation for Core Scaffolding, but instead, Appellant has named everyone who was in the building. They actually
Including
also
the-
named the demo contractor.
And the city.
Excuse
They
me?
named the city as well, right?
The city, that's a complex,
Oh, that's because of the health and hospitals.
that was the MedMal subsequent.
So
matter.
you said that CORE was also a party? I don't see that CORE was a party.
Core Scaffolding is subsequently a party to this action, based on my understanding of it. They were initially third-partied in,
Yes.
and they are, I believe, a defendant in this
I don't
action.
I don't see them, but that's okay. Continue, I'm sorry.
Sure. Just going back, again, I can speak on my behalf as well as the others for this point, the respondents. We were not the owners, we were not the GCs, we were not the CMs, we were not the agents.
So plaintiff indicates that you rely only on hearsay information. Is that accurate? How do you?
That is not accurate because we provide business records specifically indicating what marine plumbing, on my behalf, we were doing on that day. We also obtained a certified copy of the DOB record that, to an extent, for the purposes that we are utilizing it for, just to show that this incident occurred on the second story of this building structure, not the causation.
Plus the affidavits, right, or with,
Excuse me?
the affidavits are submitted by people with knowledge of what they say in their affidavits. They're not
Correct.
based on information and belief, correct? They're based on their own
They
personal
are based on
knowledge.
their personal knowledge.
okay.
I submitted on
That's
behalf
direct.
of Marine
That's direct testimony, right?
a direct sworn testimony of the director of safety who appeared upon learning this incident, and they're actually on the record email communications indicating from the CM that you guys, Marine Plumbing that is, was not involved in this action.
Right. Well, I was going to say that there was also an affidavit stating that Marine Plumbing had no responsibilities concerning the hoist.
Correct. Or
Did your-
ever contracted with Core Scaffolding.
Did the responsibilities of your site safety, you mentioned the site safety director?
We had a director of safety operations for Marine Plumbing, yes.
And do we have anything in the record that says what the extent of that person's responsibilities were, whether they extended to the entire building or they were specific?
Not specific to the project, but specific to incident investigation, ensuring safety protocols are followed, and to ensure all proper guidelines are
By
followed
everybody or by Marine?
by Marine Plumbing only and their employees, Your Honor. So they did not control, supervise, or manage, or operate this scaffold, nor had anything to do with the outside of the scaffold where these maintenance operations were being conducted.
Thank you.
Thank you.
Good afternoon. May it please the court. Christine Taylor with Brody Law Group representing Moncon Inc. I'll just pick up where the discussion left off a little earlier regarding the plaintiff's claim that there was possibly some kind of duty on behalf of Moncon to provide the plaintiff with a hard hat. A duty has to arise from somewhere. It could be contractual, it could be statutory, some other legal authority, but it has to arise from somewhere. And we've demonstrated that there was no such duty here. We presented the contract that shows we had no duty to provide safety devices to other workers working for other subcontractors on the project. We weren't responsible for overall site safety. And we also provided the affidavit of Mr. Vitulik, who was actually on the site on the date of the accident. He was working for Moncon, and he asserted that they weren't responsible for supervising the plaintiff. They weren't responsible for overseeing his work. They were not responsible for hiring or supervising any subcontractors.
So Moncon was doing the concrete work, is that correct?
That's correct. They were the concrete superstructure subcontractor. So they had no authority to supervise the plaintiff's work. They had no authority or control over the work he was doing, and more specifically, they had no supervision or control over the exterior hoist elevator, which is the area where the plaintiff says his accident happened. And I'd just like to address the last point that Mr. Pager made in his opening statement regarding the collateral estoppel argument that they made. The first motion that MonCon made was pursuant to CPLR 3211. It was a motion to dismiss. And in the papers, Mr. Pager repeatedly conflates a motion pursuant to 3211 with a motion for summary judgment pursuant to 3212. These obviously have different standards of proof, different considerations. And in the motion to dismiss, we submitted the affidavit of Mr. Vitulik in support of our argument, which of course on a motion to dismiss is not considered documentary evidence, and the court wasn't able to consider that on that motion. Subsequently, as the court rightly pointed out, we obtained the bill of particulars, which indicated the exact location where the accident happened, which was another point that was made in the motion to in denying the motion to dismiss. So we had additional information that we were able to make on the motion for summary judgment, and these were not successive motions. I'd just like to point out that the case law relied upon in the appellant brief considers successive motions made pursuant to 3211. Here we've got motions made pursuant first 3211 and then second pursuant to 3212.
Decisions within the court's discretion, right, whether to entertain successive motions?
It is within the court's discretion, but specifically the cases cited in the brief were were consecutive motions under 3211.
Thank you.
Thank you.
Good afternoon, Your Honors. Jerry DeCamp of O'Connor Red Orlando for the respondent, Real Plumbing Corp. I'll be very brief so as to not reiterate the points raised by my co-respondents. I just want to address one issue that the appellant stated here today, saying that the affidavit didn't state anything with respect to whether or not Real Plumbing is the one who provided the hard hat to plaintiff. First, again, as stated, there was no duty as a subcontractor who had installed the fire suppression system on the 4th and 5th floor. But second, the affidavit of our on-site foreman that was submitted in support of the motion does specifically state that Real Plumbing did not provide any safety equipment to the plaintiff, as it had no duty to do. Secondly, just to point out to the court as well, the owner and the general contractor, Noble Construction, who hired my client, they're both named as defendants in this case. If there was one inkling of potential liability as to my client or any of the respondents, I can guarantee you the owner and general contractor would have opposed the motions for summary judgment of the 3 defendants respondents, which they did not do. Unless the court has any questions.
Your client was in charge of the sprinkler system?
Correct, Your Honor.
And is there anything to indicate, was that work all done on the interior, I assume?
Correct. It was done on the 4th and 5th floor, and there is absolutely no nexus between my client and the plaintiff or Core Scaffolding. Core Scaffolding was the entity that employed the plaintiff and was in charge of doing the maintenance operation to an exterior hoist that my client had absolutely no connection to, did not use it, did not install it, did not maintain it. And my foreman put forth in his sworn affidavit that he has absolutely no idea he had to utilize or maintain such a device.
Thank you. Thank you all.
Thank you very much.
U.S. Bank N.A. versus Galant. Yes, you may proceed.
Good afternoon, Your Honors. Roger Levy for the appellant. May it please the court, I'll be brief. Most of the issues involved in this are by now a matter of settled law. This court has held that FAPA, the Foreclosure Abuse Prevention Act, applies retroactively, and this court has held as recently as November that the act and its application retroactively is constitutional. I think we really come down to the one question of whether the appellant's motion to renew in the court below.
Is there any case where relief has been granted to a debtor where there's actually been a judgment of foreclosure and sale, and his sale was actually scheduled, albeit that it didn't go forward, but twice sales were scheduled. Is there any case which has applied the statute in that context?
I don't recall seeing cases where the sale was scheduled. I think the key here is,
Or even there are no cases where the judgment was actually entered, right?
I'm sorry, Your Honor.
There are no cases where a judgment was actually entered, like 2 years previously.
I think the key is that there's a difference between entry of judgment and enforcement of judgment. And I think that's how the statute was meant to be read. That's the language the legislature used.
So does scheduling a sale equal enforcement of judgment?
No, Your Honor, I don't believe it does. I think the actual sale constitutes the enforcement of the judgment.
You moved for relief here after the time to appeal had expired. How does that figure into the analysis?
Well, we believe that even though the time to appeal had expired, our motion was still timely. The motion was made very shortly after FAPA was enacted. Okay, the judgment here was entered in 2021. The bank waited a very long time before doing anything and didn't really do anything until after FAPA was applied. At the time,
I'm sorry, I thought that there was an attempt to, that they did, you said they didn't do anything. I thought that they at least scheduled the sale.
no sale actually happened, however.
Well, the judgment was entered on October 19th of 2021.
Yes, Your Honor.
So your time to appeal had ran 3 years or 2 years, right, before? And 5015 says, a motion for leave to renew based upon an alleged change in law must be made prior to the entry of a final judgment, which it wasn't here, or before the time to appeal has fully expired, which it wasn't here, right? So under 5015, you don't have a right. We agree. The legislature, the courts have said that the statute is retroactive, but that doesn't resolve the 5015 issue. So the legislature could not have intended to overrule 5015 without overruling it, right? And we have to read the two statutes together.
The Court of Appeals and this court has held that there is some latitude in a motion to renew based on a change in law. The question really should be, was a motion made in a reasonable time?
What about where the time to appeal has elapsed?
We literally could not have filed an appeal because doing so would have been frivolous. The time to appeal expired before FAPA was enacted in.
Well, I mean, isn't that the whole purpose of 5015? Because the law changes all the time. But you're not going to go back to judgments that occurred 5, 6, 10, 20 years ago and say, oh, because the law has changed, this judgment is no longer a good judgment. That would literally open up every change of the law. So you have to apply 5015, don't you?
There has to be finality of judgments at some point, absolutely. But in this context, finality ought to mean actual enforcement of the.
Regardless of what 5015 says, regardless of the provisions of CPLR 5015?
Well, again, you have different standards in terms of relief from a judgment. You have different standards based on whether you're requesting a motion to renew, a motion to re-argue or a motion to vacate a default.
Is your argument here specific to FAPA because of the language that it is up until enforcement of judgment?
That is what the statute says. We think it should be applied as written, that it can be
Is
used.
that your argument as to why 5015 is not applicable, or that there is some interplay between the two statutes?
The interplay has to do with the fact that judgment was not entered. FAPA is remedial. It was intended to reach back to a certain point. Granted, not infinitely back into the past. We're not saying that the statute can be used to change a result that happened 10 or 15 years ago, or even 2
How do
years.
you reconcile FAPA with CPLR 5015? That's the whole issue. If FAPA, if the intent was to somehow disregard 5015 or state that this was an exception, would that not have been made clear?
I can't speak to the
And
legislature.
is there anything in the legislative history of FAPA that talks about somehow 5015 no longer applying, or 5015 not applying to cases involving FAPA?
We're not saying that 5015 doesn't apply, Your Honor. We're just saying that it can apply on a motion to renew even after entry of judgment where the motion is made within a reasonable time.
5015 talks about prior to the entry of a final judgment or before the time to appeal has fully expired. Here, the time to appeal has fully expired.
Yes, the time to appeal had applied, but the judgment had not been enforced.
Or
That's
prior to the entry of a final judgment or before the time to appeal has fully expired. That's 5015. It's not and the time to appeal has fully expired. But you do have time on rebuttal, I believe. No, you did not request any rebuttal time. Thank you.
Good afternoon, Your Honors, and may it please the Court. Ashley Newman of Hinshaw and Culbertson on behalf of the respondent. This case comes down to one very clear issue, and Your Honors have actually.
Well, so then how do you propose that we mesh FAPA with 5015? Which,
So, Your Honor, it's been the well-settled law of this state and even from this department that any type of motion to renew based on a change in the law, even where the outcome would change, must be made before the time to appeal has expired or before judgment has been entered. In this case, it was after both. 5015 is actually not what was moved under here. It was 2221E, motion to renew. And likely 5015 wasn't moved under here because it couldn't be moved under here because, again, judgment had been entered for well over a year, so there was no basis to try to vacate, which has a 1-year time limitation, and none of the other subparts to 5015 are applicable. There was no misconduct, no lack of jurisdiction, no reversal of a prior decision in the case, no misrepresentations, no fraud. So we are left with well-settled principles about finality of judgments, that there is nothing in the legislative history of FAPA to say that they intended to upend.
Are you familiar with the Court of Appeals decision in matter of HODUS?
I'm sorry?
Are you familiar with the Court of Appeals decision in matter of HODUS?
Yes, a little bit, yes.
So how does that case square with your position here?
So in matter of HODUS, I believe, is the case where there were nursing home being operated by convicted offenders. And so the issue there is that they obtained rights due to a sort of misalignment in 2 different laws that got passed, and it was very quickly remedied. And the parties in that case clearly admitted there was no vested right at stake. So they didn't have a vested right to continue to operate under these licenses. However, here, there is a vested right. Our final judgment became a vested property right once that the period to appeal expired. And it is very clear in Fiber, in the Germania case, which are many, many, many years old, that a vested property right, which is what a final judgment is inviolable. and it cannot be affected by subsequent legislation that is enacted. And that's exactly what FAPA is. But it cannot upend a vested property right that would violate due process in doing so. And even if FAPA is intended to apply retroactively, which this court has said, there must be a narrow reading taken of how that is applied, particularly where we are talking about a vested property right. And that is exactly what the lower court did here, and said you cannot apply it after the appellate rights have been exhausted. The entry of that judgment and the expiration of the appellate period was, as the lower court got right, a watershed event, and it vested rights in my client that are.
So how are we to ignore the actual language of FAPA, which says that up until enforcement, and enforcement here would have been sale?
Well, Your Honor, the statute does not actually define enforcement specifically, and certainly different steps can be taken to enforce a final judgment, and I would maintain that we took those here.
Scheduling of a sale constitutes steps towards enforcement, or constitutes enforcement?
Correct, Your Honor. I maintain that it is, and in fact,
Even someone could say entry of the judgment.
Sure.
Right? You can have a judgment that's signed by a judge that isn't entered, right? So
absolutely, absolutely.
one would say that, and I think in fact, in enforcement of the 50s, which all deal with enforcement, includes entry of the judgment, right? So
That's right, Your Honor.
Does the record reflect why those sales didn't go forward?
I don't believe it is in the record, Your Honor. I do know that there were several.
Well, if it's not in the record.
Understood, understood. But yes, in fact, in Appellate's own brief, they admit, it's I believe on pages 7 and 8 of their briefing, that filing notice of sale would have been a step of enforcing the judgment. And we did that here prior to FAPA being enacted and prior to their motion to renew was even filed. In fact, in a case in Nassau County, it is the Leonardo case, which is cited in our papers. Judge Sullivan very clearly took the position that filing notices of sale is an enforcement of that judgment, and to hold otherwise would be taking FAPA, which is intended to be a shield for homeowners, and essentially turn it into a sword for them, putting an end to finality for both sides of the V in litigation instead of moving forward with there being finality for all litigants involved. And most recently in Queens as well, in the Asaya case, which came out after this was briefed, the judge in that case took the same position as Judge Sullivan and Leonardo, finding that where a notice of sale was filed, that is enforcement of the judgment as far as FAPA is concerned, and therefore FAPA could no longer be applied. Unless the panel has any further questions for me, I will.
Thank you. Thank you both.
Thank you.
Harbinger Capital versus Apollo Global. Yes, you may proceed.
Thank you, Your Honor. Mark Kasowitz for Appellant Harbinger. Your Honors, this case arises from a $2 billion fraud. The fraud is that Apollo and the other respondents hid from Harbinger, which was a private equity firm, information that they had, testing that they had that indicated that
One
the
of the
network.
things is that there's a filing at the United States Patent and Trademark Office which reveals the fraud. What led you to that document?
What led us to the document, what led Harbinger to the document, Your Honor, was that in 2015, prior to 2015, the belief generally in the industry was that the only party which really knew what problems with interference with this network and spectrum were the GPS manufacturers. They were the ones that manufacture the receivers that receive signals in these telecommunications wavelengths and the like. And the general understanding was that GPS folks were the people who would know whether or not there was a problem with the spectrum.
So let's go back 5 years.
I just want to ask one quick question, may I? So when are you arguing that the statute accrued? When the cause of action accrued?
Yeah, in 2015, Your Honor.
In 2015? That's when the fraud occurred?
Oh, yeah. No, the fraud
That's
occurred.
not what you allege in your
Sorry,
complaint.
Your
Let's
Honor.
go back. I'm trying to figure out. You are not arguing That the 6 years. You're arguing the 2-year from discovery.
2-year period
So
began.
we're not talking, we all agree, we're not talking about the 6-year. We're talking about 2 years from.
Yes, Your Honor.
Okay.
That's
what I wanna
correct.
make sure.
I was going to ask you about the year 2010. You're saying that the GPS industry is the one that had the real insight as to the problems with the L-band, but didn't the GPS Industry Council in late 2010 publicly disclose that SkyTerra's proposed network would interfere with millions of GPS receivers? Didn't that put your client on inquiry notice?
Your Honor, in 2010 and 2011, the FCC.
I was going to 2011, so you're beating me to the punch. Go ahead.
I always try to do that, Your Honor. The FCC decided that it had an intent to possibly suspend the license that at that time that Light Squared had for this spectrum.
Well,
and the
it
reason
more
was,
but it was more than that, wasn't it? In 2011, January of 2011, the FCC halted the deployment of Light Square's nationwide mobile network. So doesn't that also like bring up the red flags and ring the bells?
Your Honor, there's no question but that the FCC had decided that there was a problem with the L-band. The issue isn't whether or not there was a problem with the L-band. The question is, in this case, whether or not Apollo, before selling their spectrum, the company that owned the spectrum, Light Squared, to Harbinger, had concealed information that it knew that the L-band would not
There's
function.
probably no question that they did conceal information. The question is whether you were aware of circumstances which should have led you with due diligence to have discovered it on your own.
Your Honor, Judge Friedman, you're exactly right. And what I was beginning to say was that at that time, the general understanding was that the only parties in the industry who knew whether or not there was a problem were the GPS folks. And in fact, in 2013...
Was the problem known as early as 2001 because isn't it Shuren who writes the report?
But it wasn't known, Your Honor.
Who does he work for?
He worked for the company that was purchased by, that Apollo owned.
Didn't he continue working there?
He did continue working there, Your Honor, but there was...
Wasn't that report in their files when they took over the company?
We don't know whether it was in their files, Your Honor. What we do know is that it was not in the electronic patent files. It was on a piece of paper, hard copy, buried somewhere in the files in Washington, the patent files in Washington, D.C. That's what we do know. We also
It's also
know,
in the
Your Honor,
company's files.
I'm sorry?
It's also in the company's files.
We don't know whether it was in the company's files then, Your Honor. But we do know, and this is at page...
But wait, but your guy wrote that.
No, he's not our
No.
guy, Your Honor.
Well, you took over that company when you purchased that company, so the report was within the company's file.
It was in the patent files, Your Honor, as I said.
But a
And
person
it was deep within the bowels of the company. But remember,
the company that you purchased, right? Just so we're clear.
yes, Your Honor, the company that we purchased, but we purchased that company in 2009, and by 2010, it was going through solvency problems, and we lost control of the company. So for the 1 year that we were in control of that company, there was a document buried deep within its files. And I want to point out that at page 1126 of the record, which we cite in our papers, both in our appellate brief as well as in the reply, we make very, very clear that the policy at Apollo during this time was that the management personnel instructed the technical team to hide bad test results, not disclose information that can, quote, unquote, technically hurt us, only disclose information that can help us. And when you look at the record in this case, and you see that consistently, that Apollo and the company that it owned prior to the acquisition and afterwards were making repeated representations to the FCC, to the SEC, and to Harbinger.
Council, in 2012, I mean, GPS industry 2010, FCC 2011, FCC 2012, FCC indefinitely suspends SkyTerra's authority to build out its ATC network. I mean, it's like being at the UN, wearing the flags flapping, saying, you've got to inquire, there's something going on here.
Right, and we did, Your Honor. Your Honor, in 2013, we, Harbinger, sued the GPS industry. We sued the GPS industry because we believed, and we represented this in our complaint, and Light Squared sued the GPS industry too, because we believed that the GPS industry had exclusive knowledge of what the reasons were for the problems between the GPS transmitters and the spectrum. We went and sued them. When we sued them, when you look at the complaint for suing them, when we sued them, we represented that this was the problem. This is what we believed the problem was. It wasn't until 2015, Your Honor.
Yeah, but you know, in 2010 and 2011, that you've bought as bad a lemon as possible, and you don't, and you've got these email exchanges between Falcon and Good, and you don't do anything about it until 2017?
First of all, Your Honor, it's just incorrect, Judge Friedman, to say that we didn't do anything about it. That's false.
I accept that.
That's
No,
false.
I grant
We
it.
had no reason to believe that we were defrauded by Apollo. The standard is very, very clear, Your Honor.
No, wait a second. Well, I take issue with that. October 6, 2011, everyone says I should sue you for fraud. Do I listen to them? I'm trying to find something where the GPS issue was disclosed. The idea that you had no idea that you could sue them for fraud is belied by that email.
Judge Scarpula,
And look, we're talking about whether you are on inquiry notice of a fraud.
Judge Scarpula.
Right? We agree that the 6 years has passed, so in certain circumstances, you get an extra 2.
Judge Scarpula.
Yes.
Under the Sargis versus Margarelli case, which is Court of Appeals, and it's the final word on what constitutes inquiry notice. In order to be on inquiry notice, a party must be, quote, possessed of knowledge of facts from which an opposite party's fraud could be, quote unquote, reasonably inferred. And here's the direct quote when they're explaining what that means. Quote, knowledge of the fraudulent act is required, and mere suspicion will not substitute for sufficient.
Good.
Will not be a sufficient substitute.
Well,
So
you
let's
knew
talk
you just
about-
lost $2 billion.
Let's talk about the emails then. So November 11th, 2011, at record 1033, your client is informed of the following. Your team had actual knowledge of this issue since several of your advisors were directly involved close up in managing the GPS issue with the GPS Council and or the FCC. And then the next paragraph, I plan that any potential terrestrial rollout would need to include up to $150 million in any such budget to address the expected GPS interference with mobile timing devices. It's there in black and white. So how come the duty of inquiry wasn't triggered then?
They're questions. They're questions that they're asking.
But they're questions based upon something.
No,
I mean,
no.
they're questions based on something. Why were those questions being asked?
They're questions that are being asked by the CEO of Harbinger in 2010 and 2011, okay? Because what he understood at that time was there was a problem with the FCC. Apollo had made consistent representations that this system worked fine and that it was viable. It made those representations to the FCC. It made them to the SEC, and it made them to Harbinger.
But then
So respectfully, because Mr. Falcone was asking questions and was expressing suspicion, that is not sufficient under the Sargas case and a long line of cases in New York which says that you must have, in order for the statute of limitations to begin to run, mere suspicion is not enough.
But we're talking about more than that, which is the duty to find out what the heck was going on. So before the email that I read a little bit from, Mr. Good says to Mr. Falcone, as Harbinger was well aware, interference, whether it was related to ports and waterways, GPS, Mexico, Inmarsat, radio astronomy, or the other, was always an issue with the L-band spectrum. One of the main reasons that you were able to buy this spectrum at a fraction of the cost of other mobile spectrum was the potential for interference restrictions and the regulatory treatment for this spectrum. So again, why doesn't the statute of limitation begin to run much earlier than 2015?
The statute of limitations doesn't run against, Your Honor, respectfully, the statute of limitations right there doesn't run against Apollo there. There's no single, there is
Your duty
no
of
fact.
inquiry, when does your duty of inquiry begin?
The duty of inquiry begins when you are aware of facts which give rise to an inference of fraud. There was nothing in what Your Honor just read which suggested anything about fraud. Yes, there was an issue, there was a problem with interference with the L-band, but there's not a single thing there. The word Apollo, the name Apollo is not mentioned either in that email or in any of these emails that lasted between May and November of 2011. Not once.
Okay, counsel, you do have time on rebuttal. Let's hear from Apollo.
Thank you, Your Honor.
Good afternoon, Your Honors. Jonathan Rosenberg, O'Melveny and Myers for the Apollo defendants. This court has a long and consistent tradition of affirming pleading stage dismissals under CPLR 213-8 on inquiry notice
They
grounds.
say you were running a scam, not you, your people, were running a scam, and you hid test results that nobody else knew about. Nobody else could figure it out.
And because of that, they didn't possess the facts necessary to even make any inquiry about this fraud.
Those allegations, Your Honor, are flatly refuted by the investigation that they admitted below that they were conducting. It's admitted in the Falcone affidavit.
Well, they said that those were just suspicions, and those suspicions aren't sufficient to rise to the level of inquiry notice.
Your Honor, he was accusing the SkyTerra sellers of purposely squashing the results.
When
GPS
is
receiver
that?
testing
In
results.
2011?
2011, Your Honor.
He's saying, everyone says I should sue you because you're doing all this stuff.
Exactly. You're purposely squashing the results of
And
GPS receiver
what
testing.
facts were those emails based on? They weren't based on what facts are you alleging that that was based on?
Your Honor, they had knowledge of 3 facts as of 2010 from which fraud could reasonably be inferred. First is that the network was defective, that it overloaded GPS receivers, the GPS defect.
Well, they said
Secondly,
that overload could have happened from anything. It didn't have to happen because of the GPS receptors were not working correctly.
okay, but the question is, were they on inquiry notice, Your Honor? And so they knew that that imperiled their $2 billion investment just a few months after they closed on the transaction, and they knew that during a multi-year sales process, that GPS defect was never disclosed, and it was completely at odds with the representations that the sellers had made during the sales process.
Then, didn't the FCC then order some type of a working group or some type of counsel to figure out what was going on and how it could be rectified?
Sure, the FCC then orders Harbinger and Light
Technical
Square
working group through which Light Squared and GPS communities could work together.
to work with the GPS industry to try to
Right.
find a resolution.
Yes.
At the
In
same
February
time,
2012, right?
that's in 2011, Your Honor.
January
in
2011.
early 2012.
Right.
Bankruptcy,
2012, it was publicly suspended that their approval, right? Their pending approval.
that's right, Your Honor. January 2012, they suspend the license and Harbinger files Light Squared into bankruptcy in April of 2012.
The FCC issues a formal notice proposing to suspend indefinitely SkyTerra's authorization to build out its ATC network. Isn't that so?
Exactly, Your Honor.
Based on the GPS interference.
Based on the GPS defect.
Okay.
And at that point, you bought this company, you paid $2 billion for this company based on representations that the network was valuable and able to exist, and you're not going to investigate the sellers of the company for knowledge of that GPS defect?
Yeah, but does that necessarily constitute fraud, or does just because it just didn't work, or because of what was going on, it didn't work? Does that necessarily lead to a conclusion of fraud?
Yes, Your Honor. Under this court's decisions in Cusimano, in Gutnick, in Lim, in Lane's floor covering, when you're investigating the very fraud that you ultimately sue on, you're on inquiry notice of that fraud.
So, and Light Square settles its action, and they end up having to pay attorney's fees, right?
In 2015, late 2015. Yes, Your Honor. And what does Harbinger allege that they do at that point? The first place that they look is in the filings that SkyTerra made in the U.S. Patent and Trademark Office. And within a couple of months, they find this alleged smoking gun.
Is that more than 2 years before the action is commenced?
The settlement was actually 2 years before the case was filed. The settlement that they allege gave them, put the light on in their head, was early December 8th, 2015. The action was filed December 17th, I believe, 2017, or December 21st, 2017. I just remember it was like around Christmas Eve, 2017. So it was more than 2 years.
A little bit close for comfort, but that's still a date which helps you.
That's right, Your Honor. And that was one of the arguments we made below, an additional reason that they're beyond the 2 years. And the trial judge didn't reach that additional reason for why they were beyond the 2-year inquiry notice period.
Counsel, your adversary says that pursuant to Sargas, that they had to have had some sort of facts that would have led them to the fraud. How do you respond to that argument?
Under this court's decision, Your Honor, in Hamrick, when you are aware of facts completely at odds with the representations that the seller made, that gives you facts that puts you on inquiry notice. Under this court's decisions in Gutnick and under Resora, when you suffer a major loss like this, in Gutnick it was only millions, this case is $2 billion, Your Honor, based on representations that you have a network that works, you have a fact that puts you on inquiry notice. In this case, we have a combination of all those facts. We have the investigation that triggers the Lim and Gutnick and Cusimano line of cases. We have representations completely at odds that triggers the Hamrick line of cases. And we have a huge loss immediately after the purchase, which triggers the Gutnick and Azora line of cases. So we have an overwhelming case, Your Honor, of inquiry notice.
I'm curious about the reference in the November 11th, 2011 email from Mr. Good to Mr. McLeod. The reference to the $150 million that were included in the budget to address any the expected GPS interference with mobile timing devices. How does that factor into your argument? Is that a fact that would qualify under Sargas?
Well, they submitted an affidavit, Your Honor, the Goldberg affidavit that they rely on that says, hey, what Mr. Good was talking about was something else. It wasn't the receiver overload problem. He was talking about the transmission overload problem, which was publicly disclosed and wasn't really an issue here. But the fact is, as the judge found below, that if Mr. Good is saying, we disclosed this, and Harbinger knows that it wasn't disclosed, that put them on inquiry notice, that put the obligation on them to inquire further. And
Thank you.
in fact,
Thank you. Your time is up.
thank you, Your Honor.
Thank you.
Okay, thank you, Your Honor.
CCTV?
May it please the court, counsel, Your Honor, is Milton Williams Jr. for a respondent, CCTV, and Dr. Singh by Walden, Mock, Harron, and Williams. Your Honor is conspicuously absent from Mr. Kasowitz's initial presentation to this body was any mention of CCTV and Dr. Singh. And that's because on January 26, 2018, Harbinger sent directly to Dr. Singh himself a tolling agreement, which specified the exact claims, civil conspiracy, fraud, and unjust enrichment that they brought against Dr. Singh and CCTV over 2 years later in an untimely manner. And what's a very salient point here is the fact that Dr. Singh, when he got and this is in the record, when he received the tolling agreement, he rejected it. He refused it. And if that's not classic inquiry notice, I don't know, I would submit to court, I don't know what is. But in addition to that, in December 2017, just a month prior to them sending the tolling agreement to Dr. Singh, they sued the Apollo directors on Skyterra's board for the exact same claims that they put in the tolling agreement to Dr. Singh. And what's interesting about that is the Apollo directors on Skyterra's board, Skyterra was the parent company of MSV. MSV is the company that actually developed the spectrum at issue here. Dr. Singh was a technical consultant and a board member. This is public information, which they're charged with under the Aldridge versus Marsh McLennan decided by this court, and also by Deutsche Bank versus, Azor versus Deutsche Bank. The plaintiffs in this case, or the appellants, are charged with public knowledge, public information, which it was clear. It was very easy to run a routine Google search to discover that Dr. Singh was a technical consultant and a board member of MSV. The point being, Your Honors, that they had more information about Dr. Singh available to them when they sued the Apollo directors on Skyterra's board in December 2017 than they had about the Apollo directors, and then followed it up shortly after with a tolling agreement with the specific claims. Now, the other point I'd like to make to the court, there was a new argument or a variation of an argument that may have been raised before in Harbinger's reply brief. And that was that even if they were on notice, they exercised reasonable diligence. And that was not, from my reading of the papers, ever raised in the lower court or raised in their opening brief. But to the extent that Your Honors are inclined to consider that argument, your decision in another Azor case, Azor versus Credit Suisse, decided by this court in 2016, forecloses that avenue. Because in that case, the court makes clear that, sure, it's great that the plaintiff ultimately conducted an investigation, but they need to demonstrate why they couldn't have done it earlier. And on this particular record, given the public information available to Harbinger, and given the fact, and I may have a difference of opinion in terms of the ownership interest based on the record that Mr. Kasowitz cited, in 2007, Harbinger owned about 18.8% of Skyterra. In 2008, it was 49%. In 2010, it was 100%, and the company became light squared. To my knowledge, from 2010, based on the record, all the way to the end of 2015, it was 100% ownership interest. And then in late 2015, when it emerged from bankruptcy and became legato, they still had a 44% interest. So they basically owned the company or had a significant ownership stake in the company from 2007 all the way through 2018. And on top of all the public information that could have been Googled, that was readily available to them.
So you're saying they could have looked in their own files for 6 years?
Exactly.
Okay.
Exactly. Unless there's any questions, I'll stop there. Thank you very much.
Thank you. So, Mr. Caswitz, you want to address CCTV and Singh, Dr. Singh?
Sure.
Thank you.
I'll start with that. So Dr. Singh and CCTV are basically claiming that because we sent them a tolling agreement that we were on inquiry notice of fraud. I have never seen such a proposition. I'm the oldest person in this room, and I've been practicing law for almost 50 years, and I've never seen that proposition anywhere. It's a spurious, it's a...
No, Justice Freeman.
You know what, I looked them up.
Only teasing, only teasing, only teasing.
Mr. Kasowitz, you look awfully good for someone who's been practicing for 50 years.
Yeah, there you go.
But I used to be 6'5", Your Honor. Look, it's a spurious proposition. If that were the law that you ask for a tolling agreement, that's evidence.
I don't think that that's their only argument, is that because of the tolling agreement. I think there are other issues as well that in terms of CCTV and Dr. Singh, right?
Right, but with Dr. Singh and CCTV, we did, Harbinger did exactly the responsible thing. Once after 2015, when it was on inquiry notice, as a result of this really bizarre settlement that the GPS people made, where they paid they bring an action. A motion to dismiss is made by the GPS people. They defeat the motion to dismiss, and then they settle the action, withdraw their claim, and pay the losers $25 million. When Harbinger looked at this, they said, what the heck? What's going on here? Maybe our belief that it's been GPS, which has been the villain here, that everybody else believes is the villain, is wrong. Maybe it actually is Apollo. We have to dive in and see. So with respect to CCTV, what they did was they began to look at documents. They dove in and they did a real scorched earth review of applicable documents.
But didn't they have access to those documents? Didn't they have access to those documents since 2011?
They did not have free access to those documents since 2010. They went into the company Lightsquared had gone into bankruptcy. Once the company went into bankruptcy, any access or control
Did they seek the documents?
Was cut off.
Right, did they seek the documents?
Look, I was there, okay? We had to try to negotiate with these people and make all kinds of promises. We weren't going to do this and weren't going to do that because they were concerned about disturbing what they were trying to accomplish with the FCC. We did not have access to those documents, but we found a document with Mr. Singh's name on it. And the document that we found was a board meeting where he had been present when these test results, which had been hidden for decades in their files, came out. So we named him. That's the responsible thing to do. That's what the courts want litigants to do. They don't want them just running out willy-nilly and suing people. They want them to have some basis for it. And we didn't sue, Harbinger did not sue CCTV or Mr. Singh until it had the document. So just to go back to
You have 1 minute. I'll give you one.
Thank you, Your Honor. Look, the whole argument here boils down to the very simple proposition advanced by Apollo that we were investigating. Mr. Falcone was investigating. He was asking questions. If he was investigating, then what follows from that is if he was investigating, then he must have been on inquiry notice. That's not the law, okay? And not only is it not the law, it's not consistent with the facts here. If you look at the emails, you have at page 18 of the record, you have these questions that Mr. Falcone had asked of Mr. Good, and Mr. Good responding. Second, and candidly, more offensive to me personally, are the spurious allegations that I was stuffing findings in the drawer. This is demonstrably wrong. Let me give you an example. Then he gave him an example. I think Your Honor read part of it before, and then he goes down to the end. These statements are not only dead wrong, they're at a minimum malicious and may even be actionable. He had somebody who he knew who was telling him that he was being defamatory in what he was saying. What are the inferences that get drawn from that? One inference that gets drawn from that is that afterwards, Mr. Falcone says, okay. You know, somebody told me this. I raised it with with Apollo or with Mr. Good, and he said no. So one inference is
No, it's not.
you're
It's
not
not a
de-
problem. It's okay.
so he said no.
You're not saying no, I'm not a fraudster.
I'm not a fraud. It's okay.
So one inference is
Come on,
okay,
that you can't
I'll
say
accept
that.
The other inference is no, I don't accept it. On this motion, inferences need to be drawn in favor of the plaintiff, not in favor of the defendant. This
Thank
is
you
just a
very
motion to
much.
dismiss.
Thank you all very
Thank you, Your
much.
Honor.
Take care. Cedar Capital versus Lilly. You may David leave.
He's inside crying.
Yes. Called him old. Yes, you may proceed.
May it please the court, my name is Daniel Singer. I'm the attorney for the plaintiff's appellants. This case stems from a series of purported financial transactions, which were spearheaded by defendants Brian Lilly, the other Lilly defendants, Kent, Carr, and other defendants are not parties to this appeal. This appeal stems from 3 motions to dismiss, which were filed by Brian Lilly and what's called the Lilly defendants in the briefs, Tim Carr, as well as by Tom Kent. Basically, the court...
Counsel,
Go ahead.
the issue before us has to do with the fraud, right? And the statute of limitations?
No, that has nothing, the statute limit is not even an issue at all in this case. No one brought it up in the appeal. And only one of the pro se people brought it up, and it was dismissed entirely by Judge Reed.
Well, counsel, aren't the fraud claims really duplicative of the breach of contract claims?
No, thank you, if I may explain. They're not at all. First of all, the breach of contract claims, first of all, going to the fraud claim, critically, it's very distinct from a breach of contract claim.
Okay, so let's start with that. What do you allege other than I falsely said I was going to comply with the contract?
Oh, very simple. Just very slayers. I'll start with.
Here, let's go. What else besides I falsely told you that I was going to comply with the contract? What other?
The whole thing for the first 7 claims, first 7 fraud claims, the whole thing, whole allegation is one big scam from the beginning.
But that's what fact do you allege other than I did not intend to perform this contract when I signed the contract? What else?
Okay, I disagree that
I'm
saying.
asking you, you said it was different from the breach of contract, and I'm asking you what facts have you alleged? You either have them or you don't.
I have lots.
And they have to be particular. It can't just be a big scam.
They have there's plenty of present material facts that were presented outside the contract. For example, they gave statements, okay, of past performance that were fraudulent. So they said, listen, here's a Volksbank statement of how well it did, okay? This is why you should invest. They kept giving statements which were fraudulent. They weren't actually any activity that was going on to get them to invest in further investments. That's a present material issue of fact that was not in the contracts, and that's relevant for fraud claims. Okay, also, they did make one payment. Of course, that's fraud 101. You make a little bit of payment to get them to give more. The first payment they made, $350,000, a partial payment on the performance relating to the first.
How is that a fraud, making a payment?
Because it was done because there was never any investment in the first place. Okay, they took the money, they gave false statements. Okay, they gave a little bit to show, look, here's a statement, we're gonna give you a partial payment, $350,000. Keep giving us more.
That they paid they took money out of their own pocket?
What they did, and I want to stick with a record, we're obviously further along in this case at this point, but what they did is they took the money, did whatever they wanted to do, make the investments they want, sent it to their various brokers to make investments, and gave my clients not even the amounts they actually invested in, okay?
So
that's what they did.
So counsel, I found this really strange because at the beginning, there was a 2% return that was supposed that the funds were supposed to create, right? And That didn't happen, right? There was no money paid out
Right, so,
on the investment of, how much was it? 20 million?
no, so, yeah, it's a leveraged investment, so they come up with like about 800,000, I think it was, and then
It's
they go to a bank and they
800,000,
get 20
right.
million from the bank. It's a strange financial
But then
concept, yeah.
but you don't get anything, but then you invest more money.
Well, they did, no,
So there's,
they did get the $350,000 at first. That was part of the fraud. They got a false amount of money based on false investment to
315,000.
encourage others.
Right, but 688,000 wasn't paid, so just a little bit. The
Pardon me,
return,
say that one more time, please?
the return of $688,000 wasn't paid.
I don't remember the exact number, but in total, there's about over $13 million that's due to my client. Well,
All
just
that
in
I'm saying
contract
is that
itself,
it's
over
such a strange situation because they would be promised, your client was promised a higher and higher rate of return, and on the basis of that, invested more and more money, not receiving anything back.
It's a fair question, and I like to answer it. In this, because in my experience in these types of cases, is that sometimes there's delays in getting things done, okay? This is not, you go to your stockbroker, your investor, this is private investors, okay? So, they're going in there. There are sometimes delays. It's not unusual. That doesn't excuse one from being a crook, okay? From basically taking the money and not investing in the first place.
So, counsel, I'd like to get back to the allegations. One of the allegations is that the purported investments were a scam, as that there were no legitimate investment opportunity.
Right.
Where are the particularized statements as to lead one to that conclusion?
Where are the particularized statements? They're in the complaint. We have the false statements the falsified statements that weren't
What false statements? I mean, that's what you say. You state that there was no investment opportunity, so therefore the purported investments were a scam and there was no legitimate investment opportunity.
Right.
But what is there in the complaint to particularly allege a fraudulent inducement?
Oh, because they told them that there was going to be a legitimate investment, okay, and it wasn't, and they gave.
How do we know it wasn't? Where are the factual allegations that it was not a legitimate investment?
They're in the complaint. It says very clear. It says it was not a legitimate investment. They gave false statements based on other deals to encourage them to invest. They gave false statements to encourage them to continue to invest, and there's a plethora of statements about false allegations, not to mention Mr. Brian Lewis' conduct in trying to pay it back. He was trying to take money from deals that were completely unrelated, had nothing to do with this case whatsoever, to give money to these. That's clear. That comes from one of the defendants in the case, Mr. Kent. Okay? I mean, this is a classic 101 fraud. Okay?
Thank you. You have time on rebuttal.
Thank you.
Good afternoon, James DeCristofaro. I represent Brian, Lilly, Tracy Lilly, EHG Equities, Lillyham, eCreative, and Three-Way.
Okay. So what I was trying to get at, don't we need more in the complaint, or should the complaint not state more than simply that the purported investment opportunities were a scam?
Yeah, exactly. And Judge Reed didn't find what we're looking for. In fact, in causes of action 1 through 7, he said they're statements of prediction or expectation, which isn't fraudulent. For 8 and 9, for 8, they're paid distribution, so that's a breach of contract claim. And for 9, it's a promise of first and second payments under the first and second PPM, which are not collateral promises. Those are also contained in the contract.
So your clients are not signatories to the contracts, right?
Well, correct. Brian Lilly
Didn't he
signed
sign
on behalf of other
Didn't he
entities.
sign
Right.
on behalf of Enterprise, not in his
Okay,
personal
so let me,
capacity?
yes,
Correct.
you're right. I should have said they're not parties to the contract.
Correct.
Right.
And that's what Judge Reed found as well. And, obviously, we believe that should be sustained.
And there are no, are there specific allegations that they abuse the corporate form?
There are, however, that's, in my
Other
opinion,
than saying it, is there anything that shows that they abuse the corporate form?
no, there's insufficient allegations in that regard. They're also based on information and belief, which is insufficient. And they're based on the hope that finding something in discovery will substantiate their claims. For instance, the allegations with regard to piercing the corporate veil are things like they abused the corporate form. They used the corporate form, or they used corporate funds to fund personal expenses. Those are all very vague, and they're insufficient to substantiate a piercing the corporate veil claim.
Completely dominated and controlled the corporate defendants, made business decisions for the entities.
Correct, but it doesn't say how they did that, and that's not sufficient to substantiate.
Well, I mean, a business is an inanimate object, right? Someone has to make a a live human being has to make a decision for it, but that doesn't amount to a piercing claim, right?
Correct, and what's even more deficient about the complaint is that it's a group pleading, and it's difficult for us to determine who exactly did what.
Right, I was going to ask you that because you stated that you represent the various entities, Thomas, Kent, Lilly, et cetera. In the complaint, does it really state, or I'm asking, in the complaint, does it state who did what, or?
In some degrees, yes, but in most instances, no. And just to be clear for the record, I don't represent Thomas Kent.
You don't represent, Thomas was pro se.
Correct. Brian, Lilly, Tracy, Lilly, AHG Equities, Lilly Ham, eCreative, and 3 Wide. And then in terms of, there's 2 other claims. There's conspiracy, which is 10, and aiding and abetting. There's no predicate fraud claim here, so those claims go away. And in addition, with respect to the aiding and abetting fraud claim, the complaint fails to plead how the EHG defendants, which is what we've also termed here in our moving papers as the Lilly defendants, it doesn't say how they provided substantial control, or assistance, or the source or the extent of the knowledge that they have with respect to the fraud. But in any event, those claims are deficient because the predicate
And
fraud claim
unjust
doesn't
enrichment?
exist.
There was an unjust enrichment claim as well?
Yeah, the unjust enrichment claim, the Judge Reed found that the contract did exist, and it does exist, and therefore the unjust enrichment claim is duplicative of the breach of contract claim. And if I may end on one final point, Judge Reed's decision awards costs and disbursements, which I believe includes attorney's fees, and we ask that the court sustain that portion of the order as well and award those fees and costs here as well. Thank you.
Thank you.
Okay, first of all, just to get to the last point, Judge Reed did not award attorney's fees. There was language about fees and costs, but nothing about attorney's fees. Second of all, a couple of corrections here. There's, with regards to who signed the contracts, there was EHG Ltd, EHG LLC. Both of those are his clients, okay, and both of those are here. Regarding to piercing the corporate veil, the allegations referring to, which are about 29 to 90 in the complaint, are only the introductory, aspects. What I said in my papers regarding piercing the corporate veil, there are 4 levels to piercing the corporate veil. Those were just the basic. We go to level 2, and we have even more specific allegations of Brian Lee dominating EHG LLT and EHG LLC, including in regards to the purported termination agreement, which he was causing one entity, EHG LLC, to pay money, which was actually due from EHG LTD. There was commingling with regard between Gulf Atlantic as well as between EHG LLC. I alluded to earlier in the argument, Mr. Lee, when he couldn't pay, was taking money from other investments which had nothing to do with this, and nothing to do with these entities, and trying to pay the plaintiffs in this case. Even though there was monies due and owing, to them, he allowed the company to go bankrupt or to close out in Bermuda. Gulf Atlantic did the same thing with respect to CAR. In regards to the particularizations of the allegations, I'll give one example, Your Honor. You said there wasn't a particular allegation. There was plenty of particular allegations. Looking just as in allegation number 9, Defendant Lilly on paragraph 329 just with regards to making excuses so they wouldn't commence litigation. It said defendant Lilly backed in on behalf as well as the alter ego of the other defendants would back up the excuses and emails poorly coming from Mark Ledwell. So he would, and I gave specific examples of falsified emails from Mr. Ledwell, which caused him not to commence litigation right away. Okay, as well as false promises of investment coming in. I don't know how possibly I could be more specific than I've been in this action in a complaint prior to discovery. It's not possible. I dispute this assertion about the not being particularized enough.
Thank you. Thank you both. People v. Andre Fernandez. Yes, you may proceed.
May it please the court, Benjamin Spiegel from Cravath, Swain & Moore in association with the Office of the Appellate Defender on behalf of Andre Fernandez. Mr. Fernandez suffers from severe mental illness, having been involuntarily committed to psychiatric hospitals and having had 3 forensic psychiatrists opine that he met the definition of not guilty by reason of insanity in a prior case involving false reports to the police. He's also a drug addict, having used heroin to the point he was cycling in and out of consciousness hours before he inculpated himself in 2 murders. Neither the judge nor jury heard about these impairments or how they rendered Mr. Fernandez's statements involuntary, however. This is because, despite being aware early in the case of these impairments, counsel made no effort to investigate whether and how these impairments could have rendered Mr. Fernandez's statements involuntary. Instead, counsel chose to make an argument that for suppression that the court below characterized as wildly absurd and patently unbelievable.
Well, that was based upon, I think there was an actual video of the statement that was taken of the statement made by the defendant to both the police officer, the sergeant, I think he was, as well as the assistant district attorney, or at least the assistant district attorney was present at some point.
Yes, the court's decision was based in part on the video, but what's important is voluntariness is a totality of the circumstances analysis. Well, the court stated, I believe, that the defendant did not appear to be under the influence of any narcotics, that the defendant appeared to understand what was going on, the defendant did not appear to be under any psychiatric episode, appeared relaxed, to understand what was going on, etc. The court did say that, but what is important is that opinion was uninformed by the psychological evidence here, and if there's opinion. Well, the psychological evidence was, I guess it was self-reported. You're stating that he did plead guilty by reason of insanity on a prior case, but would not how the defendant appeared at the time of the statement, is that not what we look to in terms of whether the statement is voluntary and knowing? It's a factor that the court would look to, but what the court didn't have before it was evidence of how Mr. Fernandez's psychological impairments impacted the voluntariness of his statements. Counsel instead argued only that Mr. Fernandez held a reasonable belief that he was promised immunity and $125,000 for his statements. But if we look to the testimony of law enforcement at the time, testimony of law enforcement about Mr. Fernandez's demeanor at the time, Detective Sullivan, when he picked up Mr. Fernandez, described him as agitated, paranoid, and that he was rambling on like some variety of a secret agent. And that's at pages 12 and 75 of his trial testimony. Mr. Fernandez crosses out. He writes a note at 4:15, roughly 20 minutes after he arrives back at the station, saying that he will only speak if given immunity and $125,000 for his statements. He then describes his mental illness in the video, where he acts manically at points. He also crosses out defendant on his Miranda form and writes CI, saying he's not a defendant. And moreover, after he's informed that he's being charged after the video statements, ADA Scasia testified that it didn't seem like it was computing.
So, counsel, the, so the incident occurs in 2007, right, in February of 2000?
Yes.
That's when he contacts the well, that's when he contacts the police department, the precinct, about these 2 unsolved murders. But when when the defendant is evaluated at intake on February 13th, he's diagnosed with mood disorder, NOS. The other stuff is rule out, rule out, rule out. Rule out substance-induced mood disorder, rule out polysubstance dependence, rule out schizoaffective disorder, et cetera. Then over the next 3 years, and I'm looking at your brief, you indicate the severity of his mental illness also changed. So it's not until later on that he's diagnosed with schizoaffective schizoaffective disorder bipolar type in August of 2009, and then in May of 2010, we're back to mood disorder NOS. So is there anything in the record that tells us that at the time when he gave his statements to the precinct, excuse me, and so on, that he actually was diagnosed with a mental illness?
So first, I'd like to respectfully refer Your Honor to footnote 2 on page 4 of the opening brief. Rule out indicates that there's basically not enough information to determine whether or not.
I know that.
But if you look at his historical diagnoses, going back as far as 2004, when they have the 3 forensic psychiatrists evaluate him for the not guilty by reason of insanity, he is diagnosed then with schizophrenia bipolar type. So it's similar. It's basically a similar pattern of diagnoses to what he's ultimately diagnosed with later on after he's had more evaluation.
It's just strange because that diagnosis of either schizophrenia or bipolar would remain constant usually, but it doesn't seem to be the case here. I haven't seen a record like this, which is why I'm asking you.
Dr. Jessica Pearson's opinions fills in the gap a little bit, but it looks to the it looks at the full.
It looks backwards.
It looks backwards and it looks forwards to the later diagnoses.
In 2009, 2
Yes.
years after the statements were made.
Yes.
So, counsel, I just wanted to focus for a second. So your appeal is on the denial of the 440 for ineffective assistance to counsel. Is that correct?
Yes, and also the excessive sentence.
The excessive sentence. So back to the 440. The issue is the ineffective assistance to counsel, and this is the basis for my questions. The question becomes, why was the defense attorney ineffective in assistance of counsel? How is there ineffective assistance to counsel? Because the attorney failed to bring to the court's attention or the alleged mental deficiencies of the defendant. I pointed out how he appeared on the video with the police officer, with ADA Scatia. Also, the defendant did testify before the grand jury as well. So again, why did the defense attorney, Mr. Dudley, why did Mr. Dudley's representation, why did that rise to the level of ineffective assistance to counsel?
So there are 2 reasons. It's not only the failure to have presented the evidence, it's the failure to have conducted any investigation into Mr. Fernandez's mental health history in a case that turns entirely on the voluntariness of his confessions, when there is, to borrow a term from a prior case, a ton of inquiry notice from both the grand jury, the videotape statements where he describes himself as schizophrenic bipolar type, and the grand jury where he talks about how he's been involuntarily committed. There's no investigation into how Mr. Fernandez's statements would have been impacted by his mental health. Instead, counsel chose to make an anemic argument.
Okay, so counsel chose to make that argument based upon factors which I just stated in terms of the video, grand jury testimony, et cetera. How would that lead, or how does that constitute some type of deficiency which fell below an objective standard of reasonableness under Strickland, right?
Yes. So, and also under the New York State.
Yes.
There are two reasons. The first is if you look at a case like Cyrus, when counsel makes a frivolous argument, as this court below characterized, while having failed to conduct an investigation that would have developed colorable arguments for suppression, that's sufficient for purposes of Strickland and the New York State Constitution to constitute ineffective assistance. And moreover, if you look to a case like Oliveras, which we believe is on point, the New York Supreme Court held that in a case turning on the voluntariness of a defendant's confession, in a case where the defendant is mentally ill, there, counsel failed to procure or review the relevant psychiatric records when making an argument for suppression based on voluntariness.
Even where, in this particular case, the defendant is not exhibiting any signs of mental illness during the statement to the police officer and/or to ADA Scatia.
We believe that he is, and the conduct, and there are references throughout both the interrogation to the defendant's mental illness, but also as law enforcement perceived him at the time as being paranoid, agitated, rambling on, characterizing himself as a confidential informant. There's also references to him crossing out defendant, writing CI. What we're saying is this isn't behavior as the court below evaluated it under the standard in the suppression decision. They described it as
But is it
rational.
such that you would find that the attorney's representation was ineffective? You have time on rebuttal. Bless you.
Thank you. Good afternoon, Your Honors. Vincent Revelisi for the Bronx District Attorney's Office. Let me start with the statement, the video statement. The first thing, Mr. Dudley was assigned 6 days after the video statement, so he met the defendant right around the time when the video statement was given. So besides the actual evidence of watching the statement, he had conversations with him. He said that his communication with the defendant was always good. He did not believe that the defendant was in any way incapacitated or in any way making an involuntary statement. He did not believe from watching the statement that he would succeed with that.
Was he competent to make such a determination? I mean, should he not have perhaps, you're saying he, Mr. Dudley?
Yes, Mr. Dudley.
Mr. Dudley. So was he competent to make that determination?
Well, he said that the mental disease was not the focus of the case and the drug abuse, and he had conversations with the defendant about the defense. He did have the opportunity to watch the video before the suppression hearing. He said probably even before the grand jury presentation. He advised the defendant not to testify in the grand jury, and the defendant testified over his objection. And all along, the defense attorney said that there was no problem with the defendant. He did not perceive any problem with him understanding what was happening. He did not think that that would be a successful strategy.
And he had the opportunity to talk to the defendant, to view the video, and all of that. So it wasn't that he had no idea and he did nothing. His investigation was that he spoke to the defendant, he looked at the statements, and based on and he testified to it at the hearing.
Yes. And he was aware of the drug abuse, and he was aware of the mental illness.
That the guy was clear on the law, that he understood that he understood the charges against him, he understood, and that from his viewing of the videotape confession before the suppression hearing several times, that defense wouldn't have worked.
Yes,
That's
and
what he
had-
testified to.
And he had 40 years of experience, and he had said that he had never successfully had a statement suppressed because of mental illness. If you were to look at Oliveras, which is a very good case to compare to this case, the differences in the facts of those cases make it very clear why this one was not problematic like Oliveras was. So in Oliveras, the defendant was questioned for 6.5 hours after he was arrested on suspicion of committing the crime that he initially denied. After the 6.5 hours, he had eventually confessed. And his mother told the police that he had mental problems. Here, the police were not told that the defendant had any mental problems until the defendant told them. And the police did not even know what he was going to say.
But I thought there was, your friend stated that the police officer stated that the defendant did appear to be paranoid and agitated.
They definitely said he was agitated when they first picked him up. He called them and said he wanted to talk to them. They picked him up and said right away he was agitated and wanted to talk to them. He wanted to say things right away in the police car. They said, don't, not yet. They waited until they got to the precinct, and they read him his rights, even though they didn't even know what he was going to say. He wasn't the suspect yet. So then he communicated with them and started saying things that inculpated himself. That's when they brought a district attorney in to decide what to do. And then they decided to do a video statement. And they had the statement where he said the same things he had said initially before they questioned him or before they suspected him.
So in this, and Dudley testified that like after the verdict, for the first time, defendant says to him, oh, by the way, I was found incompetent.
Yes.
Right, in Florida. Not beforehand, nothing about it, and that Dudley's impression was that he was holding that back as an ace in the hole.
In fact, the defendant called the prosecutor in the case around that same time to say, hey, I was found incompetent in Florida. So it looked like he was
Never
using
raised it before, never discussed it. Right.
Now, in defendant's own testimony, he did say at one point that he learned how to malinger and that he researched the DSM in order to talk about symptoms and found out that he had some of those symptoms. So we're not saying he wasn't mentally ill, but he was using mental illness specifically as a tool. And I suspect that's what he's doing now as well. But
Was there an active bipolar or schizophrenic diagnosis made known to counsel for defendant at any point in time?
It's not clear which diagnoses he told counsel about. That would probably have been a privileged thing that he would have said to him. But it was clear that they discussed his mental illness. Dudley said that at the 440 hearing, that they had discussed both his drug abuse and his mental illness.
As your adversary says, counsel should have made an inquiry as to past history, prior mental health history.
Well, and that's what Dudley said. He could have done that as well, and there would have been no harm. But he didn't see that as the strategy in this case, because what he had in this case instead were strange facts that really, in 30 years, I haven't seen facts quite like this either, but where they had the...
Where he calls the police to say that he has information. But he did later on state, I believe, that the reason he did so was that he was fearful that either somebody was going to snitch on him and therefore he was going to be harmed.
He gave a couple of reasons.
If he didn't speak first, they were going to blame him, so this is why he wanted to speak first.
He also said it was on his conscience. I don't know if that was true or not, but he told the police that. And so he had some reasons why he thought he might be able to help himself out by speaking, but it wasn't that he was coerced. He didn't show up and get browbeat into confession. He showed up and told the police things they didn't expect to hear. So it doesn't look like there was any reason he would have
once the
prevailed.
defendant, after the verdict, told him that, he did move for a mental competency hearing, right?
At
The
his
lawyer
client's
did.
request, he did, but he
Right?
said at the 440 hearing...
Denied, wasn't it? That was denied.
It was denied, and he didn't think that it was really worth having such a hearing, but he asked for it because his client asked him to. So, and we also ask Your Honors to affirm the sentence.
Thank you.
Thank you.
Your Honors, if I can turn to the excessive sentencing point.
Yes, so he was sentenced to 25 to life.
Apologies, Your Honor, could you restate?
I'm sorry, he was sentenced to consecutive prison terms of 25 to life.
Yes, these are two statutory maximum terms of imprisonment. Right now, Mr. Fernandez won't have the opportunity to appear before a parole board until he is 89 years old. These are serious offenses, no doubt, but we think that keeping the sentences as they are now, stacked 25 to life terms, is unduly harsh under these circumstances. There are three reasons for that. The first is that Mr. Fernandez, we believe this sentence constitutes an undue penalty, an undue trial penalty in essence.
How old was he when he was sentenced?
Apologies?
How old was he when he was sentenced?
He was born in 1967. He was sentenced in 2010,
So
2011.
he's not someone whose brain is undeveloped, and he knows what he's doing. He's a mature adult.
With all of his mental illnesses, but yes. So it's uncontradicted in the record at page 751 that before trial, Mr. Fernandez was offered a plea deal that wouldn't have resulted in a life term and was less than half of the penalty that was ultimately imposed. So
Part of that was so to spare one of the victim's children from having to come in to court, right?
no,
Right, because wasn't the female victim, wasn't the child in the next room or something and saw the defendant dragging the child's mother to the living room?
Her two children.
Her two children, and then she was ultimately killed, and then the child had to witness her body in the apartment?
Under Mr. Fernandez's statements, which is the only evidence connecting him to this offense, he was an accomplice. He wasn't the shooter. He didn't drag Ms. Almodovar into the other room. It was just.
But the point was that the child witnessed some of this activity, and the child actually witnessed the body of the child's mother, right?
Yes, that's.
And I recognize when by the time the case came to trial, the child was, I think, an adolescent, if I'm not mistaken, or at least a little older.
The child was 4 at the time of the crime, right? One of the children.
Yeah, so running it forward, 1998 too.
Yeah. So you're requesting a reduction of sentence to what? What numbers?
Either to run them consecutively, or to run them concurrently rather, so 25 to life total, or to drop the minimum to the statutory minimum, 15 to life. No matter what happens here, no matter if we get all of the relief that we ask today, there's still life on the back end. So in the event that Mr. Fernandez can't satisfy parole, that he's rehabilitated, and that he is no longer poses a danger, he'll remain in prison for the rest of his life. All that we're asking for in terms of relief is effectively that he have the chance to make that to parole before he is 89 years old.
Thank you. And again, you're doing this pro bono, so
Yes,
we
Your
thank
Honor.
you as well as your firm, Craven.
Yes.
Thank you very much. Lucas v. the City of New York. Yes, please proceed.
Good afternoon, Your Honors. May it please the Court, Adenine Medina for Barker, Patterson, and Nichols on behalf of the appellants. Your Honors, this case, the main issue in this case is whether or not the facts of the case fall within Labor Law Section 240, Sub 1. It is, we submit that Section 240 does not apply here because there was no elevation-related risk. The statute provides that it is related to the effects of gravity where the protective devices.
So we're talking about large panels, right?
Correct.
Glass panels?
Glass panels.
Weighing over 250 pounds?
Approximately. There's a little bit of a discrepancy as to the actual weight of the panels.
And cannot the weight of the object bring it within the ambit of the labor law?
Not the weight alone, Your Honor. The case law out of this court and out of the Court of Appeals provide that you need some kind of elevation. These panels were positioned on the ground. They were not being hoisted. They were not being moved. They were on the ground. And I think it's critical in this case that at the highest point, the panels were below the plaintiff's waist. They were not above the plaintiff's head or above the plaintiff in any shape or form. They were on the ground, resting, not being hoisted, not being moved, not being transported. This court has found—
They were lying vertically or horizontally?
I'm sorry?
They were lined up vertically or horizontally?
Vertically and against the wall, on the ground against the wall.
Right, so the pictures show that, I'm looking at exhibit, I guess this is exhibit D, that shows them lined up against the wall. There seems to be of some height. I mean, I don't know the height of the plaintiff. You're saying that it reaches the plaintiff's waist, but if you look at in terms of another object in the room, it seems to be pretty high.
It was actually plaintiff's own testimony. He said at the height of the panels, it was between his knees and his waist.
But wasn't it 46 inches wide?
26 inches.
46 inches wide.
I believe the testimony was between 36 and 42 inches at its height.
There isn't evidence that each panel was 46 inches wide?
I believe it was 46 inches high at its height. I don't recall the specific measurements in terms of are you talking about the width or the length?
Yeah.
Apparently, the record stated that each plexiglass panel was 8.5 to 9 feet tall, 46 inches wide, 1/2 inch thick. weighed between 200 and 300 pounds.
Correct, but the way that they were positioned, the height of the panels was actually no higher than 42 inches. And this was clearly testified by the plaintiff. I don't believe that that is disputed.
And how about plaintiff's expert's testimony that said because of the weight and the way that they were positioned, that they could have tremendous force that would, and apparently did, crush his feet?
Well,
Haven't we said that that's enough? I mean, don't we have more than one case where we said that's enough?
I don't believe the case law, even out of this court, says just the force itself. I think
No, but there's an expert opinion here. We're not making this up.
Well,
We have an expert who says the force of that amount of weight and the way that the panels were positioned created a great and intense force that is sufficient under the statute, right?
So first of all, and as we argued in our papers, the expert submissions of the plaintiff's expert affidavit was pretty speculative. The expert did not review, the pictures that the expert relied on.
Did you rebut it
were not,
with another expert's affidavit or affirmation?
We did not, but it was submitted in support of plaintiff's motion, which in addition to the fact that we argued that it was untimely.
How do you reconcile your position with Gregorian, which said that 241 applies where a load position on the same level as the worker falls a short distance if the load due to its weight is capable of generating sufficient force?
Your Honor, I believe that every single case out of this court, and I can cite several, including 2 decisions recently out of this court as of January of 2025, including Silva versus 770 Broadway owner, and Hempstead versus Hammer and Steel.
And I'm asking you about Gregorian. You didn't answer it.
Your Honor, I believe that all the cases, including Gregorian, neither of the cases support a finding that panels laying on the ground, even if they're positioned against the wall, in and of itself is sufficient to create an elevation.
Well, my colleague read what Gregorian says, where a load positioned on the same level as the injured worker falls from a short distance, Labor Law 240 subsection 1 applies if the load due to its weight is capable of generating force. Here, we have photos of the panels leaned up against the wall. There are a number of panels which are leaned up against the wall. And so, as my colleague stated, and as Gregorian states, based upon their weight falling onto the plaintiff, why is that not sufficient under 240, under the labor law?
Well, first, the photos that are in the record are not the photos do not depict the actual panels at issue.
They're demonstrative.
They're demonstrative of a different room of a different location. I do not recall the specific facts of Gregorian. What I do recall is every single other case out of this court has some kind of elevation, and the statute.
But counsel, let's talk about the affidavit of Christopher Shea from American. He said that normally, and also from Mr. Smith from Workwell, apparently normally 3 to 4 panels would be stored in a room, and that would be in the room precisely where they were to be installed. However, here, there were 6 to 8 pieces stored at a time at a weight of 300 pounds each. So when you indicate a panel, it's not a panel, it's double the normal amount of panels that would be there, and they fell on him.
But both Shea and Smith testified that the positioning of the panels is the way that they've normally done this. I believe
It's not the positioning, it's the number.
Both of them also testified that this is what they have seen in the past. Neither of them testified that this is outside of what would have been within the confines of normal. I would also highlight the fact that both Shea and Smith, or American and Workwell, were responsible for positioning of the panels. And
the testimony was that this was not the way it was normally done, right?
When they were asked as to whether or not there should have been anything done differently, they said this is the way.
Shea said that you couldn't overload the walls with too much glass. And,
I don't believe that is.
American apparently overrode what Workwell was said, which was it's too many.
Well, American positioned the panels in a fashion that was not controlled by the appellants. The appellants were not aware in the manner in which American positioned the panels, and both the testimony of the witnesses by American and Workwell stated, we wouldn't have put anything differently in terms of securing the panels. And the testimony shows that the appellants had no role essentially in the way that the panels were staged. They were not, there's no testimony that we're aware of how the panels were staged in this.
Thank you. You have time on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. Glenn Devora for the plaintiff respondent Lucas. And just to get right to it, with regard to the Labor Law 240 issue, the facts here are squarely within Gregorian. If anything, they further support a granting of the 240 as the lower court did. In Gregorian, the weight was anywhere from 300 to 500 pounds. In our case, everybody agrees it's in the ballpark of 2,000, give or take a couple of hundred one way or the other. We had the expert report that was unrebutted.
You have an affidavit from Fuchs that this called for safety devices, pointing to some industry standards of the need to have protection for something stored in this fashion. There's no countervailing experts, right?
There is no countervailing expert opinion. It would be presumably hard to get an expert to say you shouldn't be securing 2,000 pounds of glass on a wall. So we believe the lower court correctly granted the 240 sub 1 summary judgment. We are also of the opinion that the court correctly denied the defendant's motion on the 200 issue.
Are there cross claims?
Well, we're the plaintiff.
Right. So but if you get judgment on 241, you don't need the right. So that's why I'm asking you: are there cross claims?
No. If we get the 240 sub 1 summary judgment, 200 more or less is.
Yeah, but it wasn't. Who is negligent? Might that not matter?
That's what I'm asking. Does it matter as in terms
It matters in the grand scheme of the papers, not so much to the plaintiff.
Right, 100%.
But yes,
I'm
it does matter.
asking are there insurance issues and cross claims that raise
It
that
matters as to
issue?
the indemnification of hospital.
There are.
Okay.
That I think the other attorneys
But
will
it
address.
doesn't matter to you, plaintiff.
Yes.
Okay.
Thank you.
Thank you, Your Honors.
Good afternoon. May it please the court. My name is Lauren Donnelly, and I represent Schneider Electric. The order granting Schneider's motion for summary judgment should be affirmed. First and foremost, the claims by Columbia and ACC for contribution were properly dismissed. In this regard, the plaintiff, Columbia and ACC, failed to show that they were free from any negligence. The court correctly found that there are questions of fact over whether Columbia and ACC had control over the activity bringing about the injury. In other words, the placement of the plexiglass or the glass panels. And also, Workwell's project manager testified that he worked with ACC to determine where the panels should be stored, and that American's owner testified that he, a representative from the GC, directed American's employees where to stage the materials. To the extent that this is a dangerous condition case, Columbia nor ACC provided any evidence as to when they last inspected it. Therefore, there are questions of fact to their negligence, so they are not entitled to contribution. On appeal, they didn't even argue that Schneider was negligent in any way. The court correctly found that Schneider was not negligent. In terms of the contractual indemnification provision,
Your position is that you aren't anywhere near the place of occurrence at the time of occurrence.
Correct. Correct. We had nothing to do with the glass panels, or we weren't even on site. In terms of the contractual indemnification provision, it does not require us to name, defend or indemnify Columbia or ACC. Parole evidence doesn't. It was properly disregarded. That argument was properly disregarded. The purchase order is not ambiguous, so therefore parole evidence has no relevance. Again, it does not There's no privity of contract between ACC, Columbia, and Schneider, which would perhaps render them a third-party beneficiary. There's no third-party beneficiary language, and it does not, the purchase order does not incorporate any indemnification provision or any provision whatsoever between Direct Air and Columbia or ACC.
Thank you.
Thank you.
Good afternoon, Your Honors. James Strauss on behalf of Workwell. Schneider's counsel's statements to you are very comparable to the ones that I'm going to make. We have two claims against us by ACC and Columbia, which are basically that they asked us for contribution and common law indemnification. In this case, Judge Cohn listed several items. How come ACC and/or Columbia were negligent in this case, so they can't get contribution from us or indemnification from us if they were negligent. So if this case is affirmed, then the same issue should be that we don't owe contribution or indemnification to either Columbia or ACC. Same issue.
No, wait, let me just ask you though, but what if you're found partially negligent? Don't you have do you have a contractual
Partially negligent,
obligation?
that we may have a contribution.
Right, okay, that's what I'm just saying.
Right.
But
here-
you can't do a summary judgment. We don't know. We haven't had, okay, good.
But here the issue is we're being charged with contribution and indemnification. And given what the judge said in the briefs, in the decision, it certainly seems that there's at least questions of fact for a jury to decide as to whether or not Columbia and ACC are negligent. With respect to the issue of breach of contract, that is also an issue concerning procuring insurance for ACC and Columbia. We will rest on our briefs in that point. Thank you.
Thank you. You have 2 minutes to rebuttal.
I would just like to add on the 240 point that there's also an issue of fact as to whether plaintiff was a proximate cause of his accident that should have precluded summary judgment in favor of the plaintiff. There is testimony or a report that indicates that the plaintiff may have come in contact with the panels, which is what caused it to fall, and there's also testimony by the plaintiff himself that
What was the contact, counsel?
his elbow, I believe, was the report stated. It's his employer's
But if
report.
the panels was supposed to be secured, the fact that the plaintiff may have done something negligent wouldn't help you. There's no comparative negligence then.
It's our position, there's no proof that the panel should have been secured. Plaintiff's expert opinion was conclusory. He wasn't reviewing the images that were particularly relevant to this case. He was reviewing images that were similar from a different room.
Counsel, may I ask you a different question? What did you do to support your allegation that Workwell didn't have insurance? What did you put up for that?
Well, we have no proof that they do have insurance.
But that mean, okay, but you have to, so they made a motion for summary, or there was a motion where everybody's supposed to put up their evidence. What do you have for that?
Well, we believe that because we don't have evidence of the purchase of insurance, we have no way to prove that they do not have insurance. We believe that they...
Didn't you take discovery?
We did, but...
So, I mean, how, wouldn't you, if that was your claim, did you ask them for their policy?
I'm sure we demanded the policies and we did not receive the copies thereof. So
Is there an affidavit from somebody in support of your motion for summary judgment that says we asked for those policies and they said we don't have them? Anything like that?
I do not believe we have an affidavit.
Right, nothing. Okay, thanks.
Thank you. Thank you all.
Thank you, Honor.
JD Construction versus Cooper Services.
Ask them about this.
That's the effective date.
Yes, you may proceed.
Good afternoon, Your Honors. Jonathan Bondi with Chiesa, Shahinian, and John Tomasi for the appellant Talisman Casualty. I'm going to change the order of what our original brief was and deal with what I think is the more temporal issue, which is the vacator of that portion of Justice Borak's order that gave the plaintiff summary judgment as to the surety on the issue of liability. And I think that that is particularly appropriate in light of this court's April order from last year, where it vacated the finding of a default as to the bond principal copper, because now we have an open issue in the underlying case where the bond principal's default under the bonded contract hasn't been established. And paragraph 3 of the performance bond, which begins at page 180 of the record, requires that there be no owner default. And this court said in its April 2024 decision, Copper further raised a potentially meritorious defense to plaintiff's JDS breach of contract claim based on the issue of plaintiff's own default and underpayment under the parties' agreement.
So isn't your remedy then to go back to the trial court and say that we want to renew our opposition to the motion for summary judgment on the basis of liability? I mean, that's not what you're doing. You're asking us to do that, right?
That's correct.
So you can't, I think that your remedy is to go back to the trial court.
Well, the trial court did rule in December when JDS then sought to dismiss Copper's counterclaims that the breach of contract claim survived. Most of Copper's other claims were dismissed in the December 2024 order, and we referenced that order in our reply papers.
Okay, so again, isn't your...
But we're here on point 2, and I think that the first point also makes it simple to say the order needs to be vacated in light of this court's subsequent order. We can go back to the lower court and do it there.
I think that's the way you have to do it. I don't think you get to do it the way that you.
Well, I think this court can find that the court was wrong, independently of what this court found in April, to grant the motion for summary judgment as to the surety's liability, because the court should have granted the surety's motion to dismiss the complaint against the surety on the grounds that the plaintiff sustained no damages, which is really the first group of points in our brief. Case is filed in 2020. Take discovery for 2 years. You have a complaint that has one plaintiff seeking recovery of its own damages, and it produces nothing to show that it paid anybody anything. And there are 3 discovery motions made, and they're ordered in March of 2023. Give an affidavit that says, I have nothing further other than my damages summary. They put in an affidavit on March 8th, I've got nothing else. 6 weeks later, they give a liquidating agreement, which we believe is a sham liquidating agreement with one person signing for all 3 parties to the liquidating agreement. And normally liquidating agreements are sort of arm's length transactions. An owner, a general contractor, a subcontractor, everybody here's the same guy. And this court has held in the U.S. Crane case involving JDS that, Mr. Stern, you gotta wear separate hats. All right, you can't say that one bucket gets to recover if it's not a party to the contract. And here, you've got 2 parties, owner and holdings, that are somehow entitled to damages from JDS, which doesn't list on its damages summary any liability to anybody upstream.
So, I mean, isn't that a question for the damages trial?
Not when you're at summary judgment, Your Honor, and you're saying,
the
hey,
question
plaintiff,
is liability. You're saying they don't show that they actually have any damages, but they have a liquidating agreement, which we have held and has been held to be perfectly good way of raising the issue of damages.
if you show with your liquidating agreement,
Are we talking about the $4 million or over the over $4 million? Is that
they
what-
want $200 million capped at the amount of
But
the
didn't,
bond.
but didn't you have an expert who acknowledged that there were damages of about
By
$4 million,
whom?
whatever?
By whom? I can
What
only
was
tell
Joseph
you-
Healy talking about? What was
Joseph
Healy
Healy was the
talking about
person.
at page 2002 of the record, when he says that the balance is $4,154,632.36.
But we didn't get sued by that party, Your Honor.
But isn't that your expert?
It was, and that's an announcement, but no, there's no proof of payment. He's looking at numbers on paper.
Wait, so your own expert acknowledged that there was at least some damages of over $4 million, but
On paper.
but
Whose damages, Your Honor? I'm sued
all I'm
by-
asking is, so you're disputing what your expert found?
No, I'm not disputing what my expert
You're
found.
stating that your expert should not have come to that conclusion?
No, I'm disputing there's no proof of the payments. All right, there is not a single check produced. There's not a single wire produced. My client is sued by JDS for the damages that JDS itself sustained, not for what it owes to anybody else. So we're here on summary.
Was there not a settlement agreement with JDS and the holdings and the other person, the subsidiary? The owner, right, the owner. Was there not a settlement agreement between them?
There's a liquidating agreement. I haven't seen a settlement agreement. They didn't produce the contract between JDS and the upstream parties. They didn't produce an IOU between JDS and the upstream parties. They didn't produce an amount as to what. For all I know, there's a cap on the JDS agreement that says, because they're all Stern companies, I owe you nothing. If the number goes over the GMP, I owe you nothing.
Okay, you do have time on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. Andrew Bourne on behalf of JDS. Let's just take a step back here and think about what this is really about. This is a surety company that guaranteed the performance of a subcontractor on the third tallest building here in Manhattan. Indisputably, this contractor defaulted under their contract. I'll get into that, why the argument about the vacatur of the default motion that this court did back last year doesn't impact the fact that that issue was squarely before the court below, after discovery, fulsome discovery. We briefed it, we submitted our evidence. They didn't oppose it. They did not oppose it. But putting that aside, the surety has agreed to guarantee the performance. What their argument is effectively, well, because the payments came from someone else, someone's checking
No,
it.
they're saying you haven't proved that any payments were made. That's what they're saying. They're saying you haven't shown that anybody paid anybody.
Well, we do, and their own expert admits. He doesn't say that no payments have been made. He wasn't satisfied with it. He said one of his opinions was, I see circumstantial evidence for someone to conclude that these payments were made.
Were depositions taken?
Yes, depositions.
And was holding an owner deposed?
They didn't need to be because the bond requires JDS to proceed with this claim. What the big
No, but how is JDS to test that the owner and the person that you did the liquidating agreement with suffered damage or paid out something to the subcontractor?
Well, it was the same person. Michael Stern was deposed. They had the opportunity to question him about the liquidating agreement. They had the opportunity to question about anything they wanted. They chose not to.
Did they ask? Right. So the liquidated, one second, the liquidated agreement was exchanged before the close of discovery.
Yes,
Did they ask for discovery on it?
No further. They did not follow up at all.
So your friend mentioned that the expert made the determination based upon the books. Were any other evidence or discovery turned over, invoices?
Yes, we turned over what we had. We turned over what we could find. Everything was produced in this case. And their expert reviewed it and said, guess what?
So it wasn't just the books in terms of the ledger, it was also invoices, checks, et cetera.
Correct, to the extent that we had them. It was
So there's a guaranteed maximum price, right? Their claim, is it not, is that the owner didn't end up paying more than the guaranteed maximum price. What's your answer to that contention?
My answer to that is that their obligations are governed by the bond. And the bond says, the bond says specifically,
Damages is correcting defective work, completing Copper's contract, and delay costs resulting in Copper's default. And Mr. Harkins testified that the project was delayed by Cooper by 411 days at $136 million.
Is there a question, Your Honor? I'm sorry.
No, I'm just giving the information.
Thank you.
The question is, if you haven't paid over the guaranteed maximum, how are you damaged?
How? Because the bond doesn't give the surety company a windfall. In fact, it specifically says, Section 9 of the bond says, It says the balance of the contract price shall not be reduced or set off on account of any other unrelated obligations. They guaranteed that Copper Services would perform the work, which indisputably, they haven't even appealed that they did not. They defaulted.
So is the point, or is this speculation, that somehow or other you managed to bring this in under budget, but on the piece of work that was supposed to be done by the person that they were surety for, that job did cost more money?
Yes, that's what their own
But you
experts
managed
said.
you managed to keep within the total amount because someplace else you saved money, but what they were supposed to guarantee, there was a loss on.
Correct, and that's precisely right, Justice Friedman.
There's evidence of those damages by payments or?
There is through the forms of requisitions that shows an ongoing payment that was going on. Candidly, I don't recall off the top of my head if there's a cancel check for each specific requisition, but there are plenty of cancel checks and records. And what we're here, remember.
They were exchanged in discovery?
They were exchanged in discovery. And why we are here is that the court found below that there is a dispute of fact as to the amount of payments. That's the appeal here. The appeal is not whether or not there are no payments. The court said there's a disputed fact issue.
Counsel, how do you respond to your adversary's argument that because now we have reinstated the breach of contract claim, that we don't know if there was any damages caused by that?
It's a fair question that you're asking, Your Honor, and the answer is actually quite simple. As I think this court knows probably better than anyone, on a default motion, you don't have to prove your defense, right? What Copper said is, hey, we think we have a valid defense here. They did. That's what they told this court. And this court said, well, not that their defense is meritorious, that their defense is potentially meritorious. It's a potentially meritorious defense. But what happened in this case, and what happened with the surety, is that they asked for discovery on the very same issues that they claim Copper now has a valid defense for which they can test. They asked for discovery. They said it was the subject of discovery motions. We produced those documents. We made the motion. They did not raise an opposition to our motion for summary judgment after a full record, after fulsome discovery, that no, we underpaid Copper. That was the specific discovery that they requested. They never raised it. They had all the discovery. They had Copper's discovery. They had the documents from Copper. They had our discovery. And we put in our evidence on our motion for summary judgment that said we paid Copper everything to which they were entitled. Here's why. They didn't oppose it. They didn't say, no, on this requisition you didn't. No, on this requisition you didn't, which is what Copper said in their papers to this court on this default motion. So the answer to the question, I apologize that I'm running over, and the answer to the question is that was made before discovery. There was no discovery taken by Copper. They took the discovery, and they couldn't prove that Copper was underpaid. Now, candidly, we made a motion to dismiss below. I'm not going to dispute that. And again, that was on a motion to dismiss. The court said, I'm not prepared to dismiss it right now. That's what the court said. But that doesn't take away from the fact that they litigated this case, as Mr. Bondi said it, for 3 years, had the opportunity to take that discovery, never, are unable, could not prove it on the motion for summary judgment, which entitles us. Thank you, Your Honor.
Just 2 brief points. One, in response to our motion for summary judgment, they did not produce any proof of payments made by JDS. I've got a case with one plaintiff that sought its damages, not damages for what it owes to others, parents, cousins, affiliates.
But if what happened here is that the whole job ends up somehow coming in within budget, within the guaranteed maximum price, but there is a default by the contractor, which does lead to extra costs. They just, in other places, they save money, so they don't actually have any out-of-pocket on the whole job, but on your portion of it, the portion that you were guaranteeing, there was a loss. And isn't that what 5.3 of the bond means?
Well, no, because the surety didn't elect to perform here. It denied the claim, so 5.3 doesn't come into play. But I understand your point, Your Honor. If you save money with the electrician and you have an overrun with the plumber and it doesn't affect the GMP, are you still at a loss because of the plumber? The answer is maybe so. Prove it. And we have, okay, we move for summary judgment.
But I mean, isn't that the whole point of the damages trial?
It's not, Your Honor, because when you've taken discovery and the goal of it is.
Okay, so you have did you ask Mr. Stern, when you had him for deposition, any of the questions that you're saying now you don't know anything about?
And yes, we did. And when we moved for summary judgment, we said, we've been through all this.
Did you move to vacate the note of issue? Did you serve any additional discovery requests?
No.
Of course, okay, so, but now you're here saying to us, that you don't have the discovery.
We moved
You
for
didn't seek it. You didn't move to vacate the note of issue. You had that document for months before that motion was filed. Before the deposition of the one person who could have answered the questions that you're telling me now you don't know the answer to.
But we don't need to prove the answer, Your Honor. We defended this case on the claims made by JDS, and you get an illusory...
And your own expert seems to say that there were damages.
Whose?
Really?
Yours and theirs.
No,
Joseph Healy on your side.
Not whose expert, Your Honor. Whose damages?
Whose damages?
That was the purpose of our motion. We've taken discovery. I'm defending the case as it's pleaded against us. JDS and JDS
It says
only.
the circumstantial evidence produced by JDS indicates that the cost to complete the scope of the subcontract exceeds the contract balance by the amount of $4 million plus.
Who paid it, Your Honor? Regardless of what the amount is, you said there's an issue, Your Honor.
Do they have to pay in order to collect if they in fact had suffered those damages?
If you had a cost overrun, presumably you paid the contractors who did that work.
But isn't that what the liquidated agreement is for the payment to flow through the liquidated agreement?
It's a liquidating agreement, Your Honor, that says the copper damages are what I, JDS, owe Holdings and owner, and whatever I get from copper and its surety, I will pass through to you. Without production of any agreement, without production of any, this is why we moved for summary judgment.
Again, did you ask for any of that?
When we moved for summary judgment.
You had the liquidating agreement months before you moved for summary judgment.
Discovery was closed, Your Honor.
Did you move to open discovery?
I didn't need to move to reopen discovery. We moved for summary judgment. You mentioned in the prior case, hey, it's summary judgment, lay bare your proofs. So we've been defending for 2 years to show that this plaintiff has no damages. We move for summary judgment. What do they come back with? No proof of any damages. Not to say, hey, I owe my parent money.
Thank you very much.
Thank you, Your Honors.
Harnish versus the City of New York.
Good afternoon, Your Honors.
Good afternoon.
Good afternoon. May it please the court, my name is Michael Joseph, I'm an attorney with Cohen and Dykeman. Our office represents the defendant appellant's respondents, EIB Riverdale Crossing LLC and CSX Transportation Inc. on this appeal. To that end, we're respectfully requesting that this court modify the February 6, 2024 order of the motion court to award defendants appellant's respondents with summary judgment on plaintiffs' labor law claims and their common law negligence claims in their entirety. By way of brief background, this case involves a plaintiff who was employed by non-party Outfront Media, Inc., who was formerly known as TDI and CBS Outdoors, Inc.
So, counsel, since there was, this involves a change on a billboard, right?
Correct.
Okay, so since there was no construction, there was no excavation, there was no demolition that was going on at the time of plaintiff's accident, how is he protected by 241-6?
He's not protected by the labor law at all, Your Honor.
Right, so you represent CXX and EIB, right? And so
Correct.
your contention is that the labor law is not applicable in this case?
Correct. Plaintiff has no standing to invoke.
Because of the reasons just stated by my colleague?
Correct.
And the fact that the latter retracted, does that change the panorama at all?
As I'm sure that you're aware, both this department and the Court of Appeals, as I'm sure you're aware, both this department and the Court of Appeals have uniformly stated that not every fall at a construction site results in labor law liability.
Did you supply the ladder?
No, we did not. That was supplied by...
Did you have any, did you exercise any control over the ladder?
None whatsoever.
Thank you.
Is there anything further you need from me, or can I...
Nope, that's it. Thank you. You do have time on rebuttal.
Good afternoon, Your Honors. If it pleases the court, Carmine Gonsalves on behalf of plaintiff respondent appellant Edward Harnish. Your Honors, the facts here are undisputed. The job on November 21st was to go onto the property of CSS and EIB and make repairs and inspect and change billboards to a structure that they owned and had control
Oh, wait,
over.
so was it that your client was to make repairs, or was your client replacing the billboard advertisement?
Your Honor, he was doing all of the above. The law of the land pursuant to the Court of Appeals in Saint versus Syracuse is that the installation and removal of a billboard plus something else takes this and makes this a labor law case.
So is he reinstalling the billboard that day?
That was part of the work. It was a three-man job. Plaintiff was a working foreman. So his job is to come on board and take a look at their structure because they have the responsibility to repair and replace the structure. The evidence, it's
Well, again,
record
he was
595.
not there for any work to the billboard. He was there to change the advertisement. He stated that there was some inspection, but there was ongoing inspection, but it was merely investigatory.
That is not so, Your Honor. He testified, and the record's clear, that he was there to make spot repairs if it was needed. That's on the record, page 272. He was there to inspect the structure for needed repairs.
Inspect the board for any kind of deficiency or any kind of work needed to be done for its upkeep. That's what he said his assignment was. And if, go ahead.
Not to inspect in relation to any construction project.
That is, Your Honor, Justice Michael, he specifically said that, he has tools. If he had the proper equipment, he would have made the spot repairs right then and there. He said that he goes up there to make sure that the site is safe for his workers to go up there.
So,
He says,
counsel, how does this comport with Munoz, where the Court of Appeals said that similar work was cosmetic maintenance or decorative modification?
this is completely different than Munoz. And Munoz is 20-plus years old, and since then, we have Saint versus Syracuse, which is 2015.
It's so interesting that 2005 is 20-plus years. You think it? You said it was 20-plus years, and I'm looking at it, it was 2005. But, it's not like it's 1937.
I understand, Judge. So, again, if I can refer back to Saint, if I can refer to Pratt's. Pratt says, hey, we don't look at the exact, isolate the moment of the injury and ignore the general context. He says,
In Saint, though, that was a new ad that was being added to the billboard, and the size as well as the frame was being adjusted. That didn't happen in this case.
Right, that was a physical change to the billboard. There was no physical change to this billboard.
Justice Scarpool, well, that, in Saint, that it's
That's exactly what they held their hand on.
But in Saint, he wasn't injured doing any of that additional work. He was injured while walking
We're not
to help a
talking about that.
coworker.
We're talking about the nature of the work. The nature of the work there was completely different than the nature of your guy going up to make sure that that everything is going on and then changing the ad.
Again,
That looks exactly like Munoz and nothing like Saint, right?
So if we take on one extreme Saint, which says that they were adding stuff to it, and you take Munoz that says they were doing nothing but changing the ad, this is in the middle. He was changing the ad.
Wait, you said adding stuff to it. So in Munoz, they're actually expanding the size of the billboard. There's nothing comparable here.
In Saint.
Insane.
Thank you.
In Saint.
In
Saint, they're actually expanding.
They added outriggers. And
Right, but here again, he is changing the ad.
But he's also going to make repairs if he had the equipment. And he says that he didn't have the materials needed that day, but he does go up there to inspect it, and he does.
I mean, then that would mean that any time somebody went up and changed a billboard, they could say, but you know what, if there was something wrong, I was going to come back another day and fix it.
With my tools.
And that would make it a 240 claim?
If the plaintiff was a lowly laborer, I agree with you, Judge. Here, he was a working foreman. He has to go up there and he has to say if the job, and he was there 2 years ago. He was there 2 years ago where they did the repair work. And he said that when I look, I see, oh, geez, it's the same damages last time, we're going to have to come back and make the repairs. So
Does it matter if he was a laborer versus
Yeah,
a
I didn't
foreman?
understand that.
Because the work didn't change based on his title.
Yeah, it's
The
the,
nature of the project didn't change based on his title.
it's the nature of the work, and I don't think we have ever in any case distinguished between a lowly worker and a foreperson.
Lowly laborer.
Lowly laborer and the foreman on a job. I don't think we would ever make such a distinction.
what I'm saying, Your Honor, is that he was empowered to supervise these other two workers. He was empowered to go up there and make sure it was safe and to do spot repairs if he could. He went up there.
He was empowered to do so, but again, what he was actually doing and the nature of his work and the assignment for that day was to change the ad. Thank
Your
you.
Honor, I would just direct the court to record page 272, page 276, where plaintiff goes through exactly what his job was that day vis-a-vis the inspection and the repair work.
Thank you.
Thank you.
Did you have anything further? Oh, I didn't think so. Thank you. Thank you both. People v. Pedro Hernandez. Yes, you may proceed.
Good afternoon, Your Honors. May it please the Court. My name is Jonathan Edelstein. I represent the defendant appellant. The burglary conviction was based on insufficient evidence, or at minimum, it was against the weight. There's evidence of the defendant entering and leaving the building in company with other people. There is no evidence of what, if anything, he did inside the building or connecting him to what happened outside the door on the third floor.
So wait, he enters the building with another individual, and that individual has a bat. Is that correct?
That individual in the orange hoodie had a bat.
Had a bat, and he's with the individual with the bat. And then wasn't there some testimony as to the use of the bat to bang on the door?
There was actually not on the door of the third floor. There was testimony about using the bat.
The front door, not the
Yes, the
apartment
bat
door.
was used to bang on the front door.
And he was standing next to the man who was banged for not a minute, but for some time. Next to the guy who's banging the door with the bat to try and get it open.
We're not contesting that there was evidence of illegal entry into the building. What we are contesting is evidence of intent to commit a crime therein or use of a dangerous instrument therein. Even the people acknowledge, at page 9 of their brief, they say one or more people then climbed the stairs. The people even acknowledge there's no evidence that Mr. Hernandez ever got to the third floor. There are two witnesses, Mr. Tejada.
Does he have to get to the third floor in order to satisfy the intent to commit a crime therein?
Well, I think that there has to be some non-speculative connection between him and whatever went on the third floor.
You don't think somebody banging with a bat on the door because nobody is letting them in, and then they get in, is at least sufficient circumstantial evidence that they're trying to get in to unlawfully commit a crime?
Again, I'm saying we're not contesting unlawful entry.
Okay.
We're not contesting that element.
You're stating that there was no intent to commit a crime therein?
Correct.
Why are they entering the building
with a bat?
With the bat.
Well, first of all, Mr. Hernandez doesn't have the bat. Second of all, there's testimony
He's acting
with the
in
orange-clad man.
Right, he's acting in concert with
There's
the gentleman
testimony-
who's wearing the orange jumpsuit and the bat.
Well, for acting in concert, you have to have more than him being there.
Wasn't there conversations or at least some interaction between the two at the door?
No, the guy with the orange hoodie is banging.
Well, he just happened to be standing next to a guy in an orange jumpsuit who has a bat who's breaking down the door.
No.
Because he didn't have his keys, and so this guy's going to let him into the building?
Again, Judge, we're not contesting unlawful entry.
Why don't we deal with the alleged jury misconduct? Why don't we
All right.
address that one?
So there was an attorney on the jury, and there were affidavits from two jurors saying that this attorney said, he was a lawyer, and that phrased in various ways that not everything has to be proven beyond a reasonable doubt.
Is that an inaccurate statement? Does everything have to be, isn't it only the elements of the crime that have to be proven beyond a reasonable doubt?
Well, if the attorney had said that, I don't think we would be here, Judge.
Counsel, do we even know how it was phrased, given that there was no hearing?
Well, that's why there should have been a hearing, Judge. We have two affidavits which say this attorney said, you know, I'm a lawyer, and not everything has to be proven beyond a reasonable doubt. Now,
Which again,
if
is
he
not
had said,
incorrect, but we don't know, I think the point is that we don't know the context within which that statement was made, and that therefore perhaps a hearing should have been granted in order to flesh that out.
absolutely, Judge, and not only that, but to
What's the
flesh out.
reason- What's the reason your motion wasn't supported by an affidavit from that lawyer?
Well, the motion papers, I don't believe, say. However,
The motion papers requested a hearing, right?
yes,
Presumably at the hearing, all of those issues would have been fleshed out.
yes, and the
And
lawyer
hearing
could
was
have,
not granted, right?
correct.
But were your motion papers sufficient without an affidavit from that individual, that juror, who was a lawyer, to state exactly what occurred or what he stated?
Yeah, I mean, he's the one that you have this, that you're complaining about what he had to say. Isn't it from him that you should have presented an affidavit?
Well, I mean, it's not often that a juror is going to voluntarily sign an affidavit admitting to his own misconduct.
Well, did you seek one out?
We do have sworn.
Did you seek one out from Mr. Heron?
The papers don't make that clear, Judge. I do know that the attorneys below are absolute bulldogs, and I'm sure that they would have tried to get an affidavit from him, but the papers do not make that clear.
But the point is that based upon what we have, was it sufficient to grant a hearing? You have an affidavit, I think, from one of the investigators from Bronx Offenders. You have an affidavit from one of the jurors, from two
of the jurors.
From two jurors, but only one juror mentions this issue in terms of Mr. Heron stating that not everything has to be proven beyond a reasonable doubt. So again, is that sufficient?
Actually, Your Honor, I believe that both of the jurors' affidavits.
I only saw it in one, but I could be mistaken.
I mean, those statements are, in terms of the rules of evidence, are they not completely hearsay? I mean, had you presented an affidavit from the lawyer, I mean, we would have something substantial to, I mean,
the
he either
lawyers-
would concede, oh, yes, I did, I shouldn't have, but I did tell them that, or?
They're not hearsay. Oh,
Under the statute?
excuse me, Judge?
Is that required to get a hearing under the statute?
Well, I don't believe it is, Judge, but even if it were, the affidavits of these two jurors, and yes, they both EA
I'm looking at the
and
second one.
SD, mention the reasonable doubt. But
Well, he
it's
said,
not
I
hearsay.
said that we need to think about all of the evidence. He responded that proof did not have to be beyond a reasonable doubt. That was SD's affidavit.
Yes, and then EA as
EA
well
said, I felt he was telling us, Heron told us that we did not have to apply the beyond a reasonable doubt standard for everything in the case.
And didn't he say, and it doesn't one of the affidavits also mention the fact of the juror saying, well, we're not lawyers, and his response was, but I'm a lawyer.
Yes, and that he was throwing his weight around on that basis.
Well,
quite
I am a
bit.
lawyer. That was not a mischaracterization because I believe he was a lawyer. But you have time.
But
on
if I
rebuttal.
may
Yes, on
very
rebuttal.
briefly answer this His Honor's question, it's not hearsay because the statements are being offered to show that they were made, not to show that it was true that the jury doesn't have to.
Isn't it being offered to show that it's true that he told the jury that the crime does not have to be proven beyond a reasonable doubt? If he told the jury it doesn't have to be proven that beyond a reasonable doubt, that it was 6 o'clock at the time the crime is committed, and the time is not a factor in the crime, there'd be nothing wrong with that statement.
No.
Thank you. Again, you have time on rebuttal.
Good afternoon, Vincent Revolisi for the Bronx District Attorney's Office. I'll just start directly with the juror point then, Your Honors. The attorney did not do any kind of extraneous experiment or use of his information outside of the evidence in order to persuade the jury of anything. And the only other reason to have a hearing would be if he exerted undue influence on the jury. Now here, He didn't tell them
In a
anything.
criminal trial, jurors are told that they must find the defendant guilty beyond a reasonable doubt. And if the people fail to prove the defendant's guilt beyond a reasonable doubt, then you must find the defendant not guilty of the charges.
Yes.
Here, we have an individual who is an attorney telling others who are not attorneys that they do not have to hold the people to that burden, that they do not have to find guilt beyond a reasonable doubt.
That they didn't have to find beyond a reasonable doubt all the facts in the case.
Well,
No,
one
that's
of
not
them
what he
says
said.
that,
That's
and
not.
one of-
I would agree with you if that was what was stated, but that is not what he stated. He stated that the proof did not have to be beyond a reasonable doubt.
Well, actually, that's what the other juror recalled afterwards. So
Yeah, but, and again, as my colleague stated, there was no hearing which was granted, which at the time, you would have spoken to Mr. Heron if you could have found him, as well as the other jurors as to the context in which that statement was made.
Well, besides the,
Instead, the judge tries to explain it away with some phrase buried in the transcript of the summation of the prosecutor indicating that certain things didn't need to be proven beyond a reasonable doubt, and didn't even articulate the phrase as stated in summations.
well, it is part of the actual regular reasonable doubt charge to say that not everything has to be proved beyond a reasonable doubt, but in addition,
It is?
I
I don't
believe
remember that.
that only the elements have to be proved beyond.
Right, but you don't specifically state in the charge, not everything has to be proven beyond a reasonable doubt. You state that each and every element has to be proven beyond a reasonable doubt, but you don't state the opposite.
But in addition, there's one more point to make here, which is that when the attorney said something, even if it was wrong, it has to be undue influence on the jurors. And here, the jurors didn't convict, even though the attorney was telling them to convict of everything, and they specifically acquitted of most of the crimes and only convicted of what you could see happened on the video, showing they probably didn't believe a lot of the witnesses.
Does that really matter in terms of clearly determining as to whether or not these jurors were unduly influenced as per their verdict, in terms of the burden of proof? Is there not an issue as to whether or not they rendered their burden and held the people, that they held the people to their burden of beyond a reasonable doubt?
Especially when you have two jurors who, after their jury service, who from the understanding was a pretty long jury service, took the time to go get these affidavits notarized, to give to defense counsel, to then give to the judge, who didn't even do a modicum of what the statute requires, which is to just have a hearing.
Well, I don't know if the statute requires a hearing if the judge believes that the papers don't make out anything that the hearing could bear out. So if there had been a hearing and the jurors had said, yes, these
Counsel,
are...
the problem is that these jurors were deeply troubled. According to what they wrote, according to what was notarized, they were deeply troubled by the goings-on, and they believed that there was undue influence. So how do we know what happened with the other people, with the other jurors?
Well, you know that the jury did not actually do what the attorney said that they should do.
Right, they acquitted on what, 13 out of 15?
Yeah, most of the counts. And again, the counts that they convicted on were really the ones that you could see clearly from the video there was really no defense to.
We're taking your word for that, right?
Well, no, but I mean, if you watch the video, there isn't really any other explanation
We're
for
taking
breaking
your
it.
word as to why the jury came to whatever verdict they came to, right?
Well, if the judge were trying to decide whether there could be undue influence, seeing that the jurors didn't do the thing that the person they're saying influenced them to.
And that was going to be my question, is that the determination which has to be made is whether, pursuant to CPL Section 3030, subsection 30, whether or not there was a sufficient showing by the defendant for a hearing on the issue of jury misconduct.
And our argument would be that the judge, in denying that, believed that there was not a sufficient showing, that based on what the allegations were, there was not a sufficient showing that if those allegations were proved that it would have been.
Based upon the judge's belief, not based upon any statements made by the other jurors or any inquiry by the judge as to the other jurors, or even of those jurors as well as Mr. Heron.
I don't want to suggest what the judge believed the jurors would say, but I do mean to suggest that the judge believed that there was no indication here that the jurors would have been unduly influenced, given that what was said in the allegations and what the jurors did as the verdict.
And the question
That's the
becomes whether
problem.
that
That's
was.
so speculative. I'm
Right, is
sorry.
that,
That's
no, is
incredibly
that a
speculative.
reasonable?
Why not just ask the jurors, were you unduly influenced by, if you take just the fact that the juror said, SD said, that lawyer told me I don't have to find defendant guilty beyond a reasonable doubt. And that automatically, to me, would say, I need a hearing to see, because that is juror misconduct. If that was said and the juror believed it and did it, that's straight up. So then why is it that the judge gets to decide that that juror didn't? How could the judge decide? Because they acquitted?
Neither of the jurors said that it affected their verdicts, and they're the ones that are actually reported.
Well, I guess because maybe that, it's an affidavit, but how could the judge decide that without a hearing? That's the only question.
Well, because the allegations in the paper should have said that there was some undue influence that actually affected the jury's verdict in some way.
Well, that's the point.
Why would they give the affidavit? I'm sorry.
Go ahead.
I didn't mean to interrupt you.
Go ahead.
Why would they even give the affidavit if they didn't feel that there was some kind of influence on them in the jury verdict? Why would they go to that problem? I mean, that's what I'm saying. You're saying because they didn't spell it out in their affidavit. And I'm saying it's just as likely that they gave the affidavit because they felt that way as the judge finding because they didn't acquit on something else, they didn't. The only way to resolve it is with a hearing.
And why would not the mayor's statement again that they were told that they did not have to hold the people, that they didn't have to, you didn't need beyond a reasonable doubt to be proven on for everything, however it was couch stated. Why was that not enough in and of itself to grant a hearing, to hold a hearing?
Well, there's no reason to believe that they followed anything that might have been said that was wrong. So they didn't give any indication that they were influenced by what he said, other than that he said it.
Once you talk about the burden of proof in a criminal case, as opposed to, given a presumption of innocence, et cetera, once you talk about the burden of proof, I think bells go off in your head that, maybe there should be a hearing to flush this out. It may well be that the jurors, I don't want to say disregarded this attorney, but they based their verdict solely upon the evidence and they held the people to their burden of proof. That may well be true. But under these circumstances, I don't see why that statement alone in the two affidavits does not rise to the level of a hearing.
Well, if Your Honor disagrees with us, I know what's going to happen, but we
You know what's going to happen. You never know what's going to happen.
But our position would be that the judge did not see enough there to find that there was undue influence.
Thank you.
We ask to affirm.
Briefly, Your Honor, responding to counsel's point regarding the partial acquittal, paragraph 12 of SD's affidavit stated that Mr. Heron, quote, was trying to convince us, meaning the jury, that if you did not choose one count, you had to choose the other one, which automatically meant the defendant would be convicted of something, unquote. That's what the jury did, Your Honors. They acquitted him of all but two of the counts and then convicted him of two. That could be due to undue influence. That's why a hearing needed to be held here. And again, I think also from the fact that Cynthia Rodriguez, the Bronx Defenders investigator, did go out and speak with Mr. Heron and, at least gave her account of what he told her. Mr. Heron informed her that the jurors in the case were confused about the law. He was apparently giving her his point of view, but...
They were confused, and as a lawyer, he had to help them, right?
Yeah. So there was at least secondhand statement put in from Mr. Heron, and I think it can be inferred from the fact that this affidavit is coming from Ms. Rodriguez, the investigator, that Mr. Heron refused to provide her with an affidavit.
I think that would be speculative. She's an investigator for Bronx Defenders who represents the defendant, so I don't know. She may be an interested witness.
Well, she may be an interested witness, but that doesn't mean that her testimony is automatically to be discounted.
No, I'm not saying that it would be. I'm just saying she may be an interested witness.
That's why we have hearings, and that's why we have cross-examination, Your Honor.
That's why at a modicum, you could have had a hearing on this issue based on all of that evidence presented to the judge.
And if there are no further questions, I'll rest on the briefs and ask that the court reverse.
Thank you. Thank you both. Hallie v. Craven. Craven.
But it seems like it's the same now. This is what it looks like.
Yes, you may proceed.
May it please the court, Judd Grossman on behalf of Ann Craven. The lower court held that Ms. Craven has made quote-unquote extraordinary efforts throughout her career to achieve her quote-unquote professional success.
So, counsel, we're all familiar with what we might consider great works of art that were not valued properly during the lifetime even of the artist. And notwithstanding protracted efforts to promote that artist, by the artist and by others, isn't the value of art something that's subjective and something that fluctuates as a rule?
Sure, and to be clear, you're correct, but both artists here have extraordinary oeuvres or bodies of art. But we need to focus on what the asset is that's at issue here, and its scope is very narrow. We're only talking about the primary artwork by each of these artists. We're not talking, as the other side and their experts did, on artworks generally, the secondary market for artworks generally, or even the secondary market for these artists' works. We're only talking about their primary market, and the reason that's important.
But your client's art could be beloved by some and considered absolutely awful by others, notwithstanding her best efforts.
That's fine, but the standard that this court has articulated in Greenwald, in Ferraioli, and others isn't the ability to control the market or guarantee success. Any small business owner would tell you they can't do that, which is why it's not the standard. The standard that this court has articulated time and time again is the ability to control business decisions. And that's what these artists do as it relates to their primary markets. Again, we're only talking about their primary artwork.
So we don't look to see whether this is a passive asset or not a passive asset?
I'm sorry, Your Honor?
We don't look to see whether this is a passive asset or not a passive asset?
You do, and that's the standard that I just quoted from.
So if it's a passive asset, why then would we not look to the date of sale as opposed to the value at the time of sale as opposed to when it was produced? You want us to look to it as when?
No. When you say look to it, again,
meaning the value
of a primary sale. So think about it as far as an IPO of securities as opposed to the secondary market in securities. When we're talking about the IPO, it's very controlled. The pricing, the roadshow, the allocation, who they're going to issue these securities to and at what price. There's no guarantee that that offering will be a success. And there's certainly no question that once it's hit the secondary market, those decision-making abilities are out of the control now of that owner. But it doesn't take an economist to know that when someone literally owns every asset in the market, and that's what the primary market is, you easily can influence, not control, but influence pricing and value, among other ways, by deciding how much to introduce into the market. She literally owns every single painting comprising this market. So the other side's focus and the lower court's failure to distinguish between those primary market works and the secondary market works is dispositive here. There's no question. They don't disagree with this. Question about which paintings to introduce into the market. Solely
No, but the question is the asset going to benefit? If it's passive, right? If it's a passive like artwork, whether as opposed to an active asset, where it's unfair for someone to be working on that asset and that asset change in value during the time, and that the other party get the benefit of that windfall. But all we've seen here is evidence that no matter how much somebody markets their work, and no matter what happens, artwork is not primarily affected by the person's efforts to market it, except your client thinks that hers is, and I get that.
No, Your Honor, embedded in your question, though, is the failure to distinguish between primary art and secondary art. That's very important, because that's what's lost in the other side's discussion. And
Wouldn't that still be an issue for trial?
It could. It could, and quite frankly...
This decision, Supreme Court made its ruling, and that doesn't preclude this issue being explored further at trial.
I think that's right. And this court's holdings in other cases that my friends have cited say perhaps it is premature where there are other considerations at play. But I do want to just point out in response to your question about art as a subjective asset generally, again, we're only talking about the primary market, but in Greenwald, the court said the results of your decision-making, whether they're beneficial or adverse, if they're the product of your decision-making, then it's active. We're not talking about art generally being susceptible to whims, no different than stocks. Stocks are susceptible to market whims. But when it's an actively traded stock portfolio, like in Greenwald and Ferriola...
No, I think it is different because I think it's more subjective. And what I may find to be, something, a piece of artwork that I'm going to pay $20,000 for, $200,000 for, my colleagues may not find the same. They would not value it at the same amount because it appeals to me in a certain way that it doesn't appeal to them, as opposed to stocks and bonds, which is totally different.
But, Your Honor, that question goes to how the appraiser in this case will conduct her valuation, not what the date of that valuation should be. You're right. But my career is focused in the art world. There are subjective whims that go into that. The question today, though, isn't how we value each of the paintings. It's as of what date. And it's as of the date of commencement because she is like a sole business owner. Her affidavit says it, his affidavit says it about him. They control how to market, sell, promote, what works to put out into the market. That's all unrebutted, not only by the artists, but by their gallerist. They have a shared gallerist here. And that's the other point the court overlooked below, is not imputing to these artists the work that their gallerists undertook as their agent.
But if we set the valuation, regardless of where you set the valuation, would not all of this additional testimony be elicited at trial in terms of, well, maybe she held back, or maybe she flooded the market with her paintings, et cetera? All of that would still be admissible. All of that evidence would still be admissible, would it not?
It could be, and if the court wants to vacate the lower court's ruling and defer it until a trial, that's fine. But I think your point about flooding the market's an excellent one, because that's right. She or Mr. Haley have the ability to impact the value of their inventory by deciding whether or not to flood the market, for example. That's why this asset is so unique. We're not talking about the market generally. We're talking about their studio filled with their art, which only
But
they
you will agree with me that the cases that we looked at say that artwork is a passive asset, not an active. Okay, I'll cite you.
No, not primary artwork.
I can cite you a couple of cases, but sure. Okay.
Primary artwork.
Thank you.
You do have time on rebuttal.
Thank you, Your Honor.
I think good evening might actually be appropriate now.
Unfortunately.
Brianna Denny for Respondent Peter Halley. I would just note in regards to counsel's argument that the record shows that after an auction, 3 months after commencement of this action, Ms. Craven's primary market prices tripled due to the outsized market, or outsized auction result that happened. So therefore, the primary and the secondary markets are impacted in regards to valuation. This court and the Court of Appeals has been very clear that marital property is to be construed broadly, and the motion court, the trial court, has the discretion to select a valuation date.
So may I ask you that specifically? So if that piece of art had been valued at the date of commencement, it would have been valued at like 20 grand, right?
Correct.
And it's sold for 600 grand, right?
Correct.
So in that event, your client may have gotten a huge windfall.
However,
right? If it was valued at the date of commencement rather than at the date of trial.
However, there's the flip side to that too, which is in my client's affidavit, which is his works have sold previously below auction estimate or not sold at all.
Right.
And therefore, the value of all of his works have decreased because of those auctions. So these two markets are very related to the value of the work.
And the sale of Miss Craven's piece, the one that got the, I don't know how many times the value, from 20,000 to 640K, that was positioned at an auction where a very well-known artist was also, that person's work was also for sale, right?
Correct. That was a Warhol that was up for sale.
Warhol.
That created what was known at that point as sort of a feeding frenzy at that auction because of that Warhol that was also for
The
sale.
presence of the Warhol at this auction created a buzz.
Correct.
And, yeah.
And neither of the parties had any notice that this auction was going to happen, when it was going to happen, and what works would actually be sold at that auction. So I would simply state that the trial court did not abuse its discretion in setting a trial date valuation for both parties with regard to their artwork. And if there are any factors that can and should be looked at about efforts that either party have made, both to increase or decrease their values, that would go into what the equitable distribution would be, and maybe it's not 50%, maybe it's more or less than that.
So you're not disputing that the wife can submit evidence that the husband flooded the market to reduce the value of all the art.
Absolutely.
And that therefore he should get 20% of his art and she should get 80.
Correct.
And the same thing with respect to art that's sold at a higher level at a certain period of time, right? That you're not disputing that the party can argue, well, it was because of how I positioned the art on that date that number came in.
Yes, our position is that it is incredibly difficult, near impossible, to do anything within the art market. Otherwise, there'd be
You'll start with the ruling from Supreme Court, but that doesn't mean the issue, it's not something that evidence can be presented on a trial.
Absolutely. Same as, for instance, a piece of real estate that somebody has really diminished the value over time. You could submit evidence of that as well.
And there's nothing that in Supreme Court's decision which would preclude that additional evidence presented.
That is
presented
correct.
at trial.
That is correct. And we would ask that you affirm the Supreme Court ruling. Thank you.
Thank you.
Very briefly, Your Honors, the questions of equitable distribution are separate from the question of whether to deem this an active or a passive asset. And I think my colleagues' focus on the sale at auction illustrates just how there is a difference between the assets we're talking about. That wasn't a sale by our
But aren't we
client.
talking about the valuation, obviously, in terms, it's going to go to what percentage the wife gets and what percentage the husband gets?
Of an equitable distribution, so it's a percentage of the value of the asset to be calculated
Yes.
now. That asset to be determined based on whether it's active or passive. The work that was sold at auction was out of our client's hands, just like a stock trading freely on the open market. She didn't sell the work. She had placed the work with her gallery's help years before into
She received a percentage or
No.
some monies from that sale.
No, absolutely not. Once she sold it on the primary market, it's out of her hands. That's the distinction we're making that's so fundamental that I really think is being looked over here. She has nothing to do with that sale. She's absolutely right, my friend on the other side, that sale and the results would impact how the gallerist prices the work on the primary market. But to be clear, if it were totally out of our client's control, the primary market and secondary market prices would be
I
even.
have to stop you a second. So are you saying that all sales of your client's art is done on the secondary market?
No, that's
only
the point.
Only through a gallerist who's got complete control over her work?
No. And I'm sorry if this were unclear from the papers. The primary market of art is when the artist paints the painting, sells it through a gallerist. Now it's on the open market. Unless you've contracted on that first sale to get a piece of resale royalties, the artist then has nothing to do.
So the 20,000 versus the 600,000, how much did she recoup on that?
Nothing. She had nothing to do with that sale.
She got no money?
No, that's the point of the distinction we're trying to make, and I'm sorry that I'm struggling to make it apparently. The primary market is where she has the ability to exercise control over all these decisions.
So was the sale of this particular piece on the secondary market or the primary?
Secondary market. Secondary. And notwithstanding that sale, her gallerist still prices her numbers well below. Why? Because he, as her agent, has the ability to exercise control over business decisions, not the ultimate outcome.
What's to stop your client from presenting evidence such as what you're presenting here, the arguments that you're presenting here?
Hopefully nothing if the court affirms the lower court's ruling. But the question has impacts now on, for example, how the appraiser is going about her job of valuing the artwork. So that number right now is fixed to the current value as opposed to the date of commencement. If this court were to either vacate the ruling or defer it, at least the appraiser could be doing both simultaneously. But right now, her hands are tied in what she's able to look at.
Thank you. Thank you both.
Thank you.
Last but never least is Tam Consulting versus Cincinnati Insurance. Yes. Mr. Tam.
Good afternoon to the court. This is I guess, a messy case.
Sir, speak
many
into the
parts.
mic. If you can bend the mic towards you.
Sorry. I guess this is a bit of a messy case here.
So, Mr. Tam, you are here pro se representing yourself. Who's representing Tam Consulting?
I am
So is Tam Consulting a corporate? What type of
sole
entity?
proprietorship, Your Honor.
I'm sorry?
Sole proprietor.
Thank you. Please continue.
The plaintiff's appellants seek to reinstate all claims against all defendants on the grounds that the policy that was delivered is incomplete and missing 2 of 5 policy coverages, 2 of 4 of the inland marine coverages on a binder were not delivered. And notably, the binder has no limitation of suit on it, so I guess the 6-year limitation of suit for contracts would apply in New York State. There's also a settlement agreement that's referenced in the 10% note release. The settlement agreement was not attached in the defendant's papers. No payment has been received for injuries under the 10% note release, which is contrary to the Court of Appeal in, I think it was Best Yatuka. It's in my papers. There's no recital of past consideration, no itemization of it as mandatory under Insurance Law 216 and General Obligations Law 5-1105. There was no preliminary conference, no depositions, no discovery, contrary to CPLR 3212F. Payment was made by Cincinnati after the 10% note release on property matters after the release, which they claim applies. I claim it applies for injuries, which the release states, and Cincinnati did not use its property release, instead they used an injury release. The lower court, specifically in their order, highlighted that if TAM does not receive payment of $276,877.99 within 30 days of the receipt of a signed and dated release by Mr. Flynn, TAM shall be entitled to receive interest at a rate of 10%. I was told by Mr. Flynn that I would be receiving an annuity of about $27,000 per year. He highlighted the payment of 10% and asked me for the names of my beneficiaries in case I wasn't around any longer. The court in his order specifically noted in NICEF number 129, NICEF 129 in the lower court, that there was an ambiguity given forward-looking language indicating a future obligation of payment by Cincinnati, contrary to release paragraph 1, which indicates a material and triable issue of fact requiring denial of the MSJ. Incidentally, Cincinnati has obtained payment, I believe, of $20,000 from Catenary, who did some of the demolition, but has not handed that $20,000 over to me, even though there is a made whole rule under subrogation. Cincinnati has also not satisfied its duties in the policy to pay expenses necessary to protect property, even after settlement as part of any winding down. I believe the court moved too quickly in reaching their orders. Okay, I will rest on my papers for now.
Thank you.
May it please the court, William Kreckstein on behalf of the Cincinnati Insurance Company. Your Honors, please don't take my brevity as a sign of disrespect. Our papers are clear as far as what our position is on these 4 consolidated appeals. First one is the engineering defendant's appeal. I'll leave that to them. The second one is in regards to Judge McShann's decision dismissing 24 out of 25 claims by Mr. Tam against Cincinnati. Each of those are specifically laid out by Judge McShann. The law is clear. Most of them are subsumed in the breach of contract claim, which is barred by a 2-year suit limitation period. The case was then transferred to Judge Gomez, who then granted in part Mr. Tam's motion for reconsideration, specifically
Is there still
limited.
a pending summary judgment motion at Supreme Court?
I'm sorry, Your Honor.
Is there still a pending summary judgment motion at Supreme Court?
There is, Your Honor. There is a pending motion for summary judgment on a claim for valuable papers and fine arts in regard to the second claim, which is part of what this appeal is about. So that motion is currently pending before Judge Gomez. You are correct. As far as the last appeal, specifically by Cincinnati, that was in regard to count 10. Subsequent to that, because again, this appeal goes back to 2022. So subsequent to that, Cincinnati filed a motion for summary judgment on count 10 that was granted by Judge Gomez. So that appeal is moot. Cincinnati, pursuant to the clerk's instructions, has prepared a stipulation to withdraw that portion of the appeal, and we'll get that done as soon as the argument's over. With that, Your Honor, I'll rest on the papers.
Thank you.
Good evening. May it please the court. Nicholas Paslow for defendant respondents, Turner Forensics, Turner Engineering PC, Daniel Turner, and Troy McClure. My clients were dismissed in their entirety by the lower court. Appellant has appealed that, but not addressed any of the arguments in his opening statement and only addressed the appeal as to my client's claims briefly in their brief. Unless the court has any questions for myself, I will yield my time.
No, thank you.
Thank you. Am I on? We're not technically on your appeal.
No, I didn't put you on.
That's okay.
Okay. You want to sign that?
This
is the stipulation to discontinue our appeal on the motion for summary judgment. Thank you.